Morning, guys. Can you see me and can you hear me? Guys, can you see me and can you hear me? Okay, guys, can you hear me and can you see me? Can you hear me and can you see me? Good morning. So, finally, the last day for your law revision, the last chapter. Excited? Did you go back and revise yesterday a little bit? Good morning. Good morning. Voice is clear, no? Just give me a thumbs up if the voice is clear. We'll continue then. Okay. So let's start with Indian Contract Act without delay because anyway, this chapter is going to take a lot of time for us. Yes. So Indian Contract Act 1872. We already know this chapter is for how many marks? 32 marks. This time it was given for 36 marks, as in there was a 6 marks ka question ka, or sorry, 38 marks. It was given, there were 2 questions of 6 marks which were given as a choice that you could do any one of it. So this time it went on for 38 marks. Special contracts is a very important section from which they ask a lot of questions. But then again, I know one thing, we trust the institute that there can always be something different than what you expect, right? So Indian Contract Act 1872 came into force on the 1st of September 1872, applies to the whole of India. What is a contract? A contract is an agreement enforceable by law. When I say enforceable by law, what exactly do I mean by enforceable by law? One party has a right to sue the other party. Right? When I say enforceable by law, what I really mean by enforceable by law is one party has a right to sue the other party. That is what we mean by enforceable by law. So it's an agreement which is enforceable by law. What is agreement? Every promise and every set of promises forming consideration for each other. And what is promise? A proposal when accepted becomes a promise. So if I see the essentials of a valid contract, there are certain essentials which are given by law, and there are certain essentials which are over the years have been in what are these two parties' intention to create a legal relationship, certainty and possibility of performance, and legal formalities. Now, let's talk about the different types of contracts that we have. Is there a problem, guys? So the first one is void. What exactly is void? Not enforceable by law. That means when I say not enforceable, we cannot sue each other. Not enforceable means what? Cannot sue each other. When I say void, it's very important to understand that void can be void ab initio, that is void from the very beginning, or it can be a void contract that is becomes void at a later stage. Void ab initio is void from the time the contract was made, and that means it was never valid, it was void from the time it was made. Whereas when we talk about void contract, it becomes void at a later stage. That means when the contract was made, it was valid, but before the contract could be performed, changes take place which makes the performance impossible, making the contract void. The next one is voidable. What is voidable? Voidable is enforceable at the option of one of the parties, but not at the option of the other or others. When I say enforceable at the option of one of the parties, what it means is that one party can sue the other, but the other party cannot sue. Right? But the other party cannot sue. These are the list of all the cases where the contract is void ab initio. Now, what is valid? Both parties can sue each other. What is valid? Enforceable at the option of both the parties. When I say enforceable at the option of both the parties, what it means is both parties can sue each other. Illegal, it is void as well as punishable by law. Void to it is, you cannot sue each other. Cannot sue each other. But apart from that, you will also be punished by law. Chakki piecing and piecing. Bharatiya Nyaya Sanhita, it considers these acts as crimes. Unenforceable, which is not enforceable due to some technical defects. That means the substance is good, but there are some technical defects. In fact, if I remove the technical defects, the contract will be enforceable. Now, on the basis of formation, contract may be express, implied, or e-contract. Express is by words, oral or written. Implied is other than by words. It can be by law, by actions. When it is by actions, it's tacit. When it is by law, it's quasi. And e-contracts are contracts which are entered over the internet. Then on the basis of performance, a contract may be unilateral. What is unilateral? One party has performed even before the contract was made, or at the time of making the contract, the other will perform after the contract is made. What is bilateral? Both are yet to perform. Executed, both have already performed. Executory, reciprocal promises are yet to be performed. Reciprocal promises means what? Reciprocal promises means dependent promises. That is, the promises are dependent and we are still to or yet to perform them. Now, here I just want you to understand this one thing. If the main contract is void, the collateral is valid. Whereas if the main contract is illegal, the collateral is also tainted with illegality and hence it is void. And now you have sat cozily for a very long time. So A bets with B. A lost the bet. A is a person who resides in, let's say, Bangalore. A makes a bet with B and A lost the bet. Obviously, lost means he has to pay money. He takes a loan from C to pay B. So I repeat again, A bets with B that I will, he bets with B, whatever, and he lost the bet. So he lost the bet, that means he has to pay money to B. So to pay the money to B, he takes loan from C. Now later he refuses to pay C. My first question is, can C sue A? And what would be your answer if A was from Mumbai? Guys, giving you a minute, think about it and answer. Okay, so you are saying yes. Okay. In the first case, can he sue? Yes. Now, if A was from Mumbai, then in Mumbai, betting is illegal. And any agreement which is illegal to the collateral to the illegal agreement is what? Void. Then can C sue A. Did you understand what I am trying to tell you? So now you are giving the answer or you did not understand. If the contract is in Mumbai betting is illegal. Any agreement which is collateral to illegal is what? Void. So in the second case, can C sue A? No. I hope it's clear to all of you. I've already explained it again. I hope it's clear to all of you. In wager, if you remember, we had done in Gujarat and Maharashtra, wagers are illegal, not just void. I hope now it's clear. I hope now it's clear, guys. Now, so with this we are done. We are going to start with the essentials of the valid contract now. So the first one is offer. What is offer? Willingness to do or not to do something with a view of obtaining the other person's consent to such acts or abstinence. Right? Willingness to do or not to do something with a view of obtaining the other person's consent to such acts or abstinence. That is offer. Now, the person who makes the offer. So let's say A made an offer to B. What do I call A? A is the offerer and B is the offeree. When B accepts it, he becomes the acceptor. And then A becomes the promiser and B becomes the promisee. Right? Now, what is a general offer which is made to the world at large, to the public? Anyone from the public may come forward and act accordingly. Anyone may come forward, act accordingly and accept the offer. That means what? The fact that you acted on that offer is an acceptance of the offer. What is special offer made to a definite person or group of person? Who can accept it? Only the person or group can accept. Only the person or group to whom it is made can accept it, right? Then what is cross offer? Identical offers. Both the parties are making the same offers to each other, but both are unaware of the other's offer. I repeat again, what is cross offer? We are making same offers to each other in ignorance of the other's offer. What is the result of cross offer? The cross offer results in both the offers will lapse. What is counter offer? Counter offer is when I have made an offer to you, you modify it and accept it. You have made a counter offer. And what is the result of counter offer? The result of counter offer is the original offer will lapse. What is standing or open offer, which is open for acceptance over a period of time? Once the period is over and you have not accepted, the offer also lapses, right? Now, what are the rules of offer? First and foremost must be definite, clear and not vague. If the terms are vague, the terms of the offer must be definite, clear and not vague. If it is vague, it's not valid. Then next is, It must be made with an intention to create a legal relationship. So must be made with an intention to create a legal relationship. Today I will upload all of these documents before the exam. You refer to these, just quick wala thing. It will be so easy. One more very important thing here. When you are preparing for the right now you are preparing. Some topics are super easy. You just look at it, you will be able to follow. Some topics may be very tricky. When the topic is very tricky, make a note in the book only. Refer later, RL. That means later also I cannot just overview. I cannot do that. I need to check it very carefully. So whenever you are reading it, make sure you do all of these things. It will make your exam reading very easy for you. Then, may be expressed or implied. What is expressed? Expressed is by words. What is implied? It is by actions. Whereas when we talk about implied, implied can be by law, by actions. Here we don't have offer by law. There is no such concept. So it's always by actions. When it is by words, it may be what? Oral or written. Then it must be communicated. Communicated to whom? To the offeree. So, unless, guys, I have a question for you. You have sat for 30 minutes without doing anything. Tell me, when I say it must be communicated, is it mandatory that offerer alone has to communicate, or can he use someone to communicate the offer? Jaldi se bolo. Exactly. He may communicate directly, or he can communicate it to someone else. Not mandatory that he only has to communicate. But the whole point is communication is mandatory. That should be done. Is it clear to all of you? Is it clear to all of you? Yes, yes. So moving forward, and from this only we get the next rule. Offer cannot be accepted in ignorance of the offer. If you remember the name of the case, Lalman Shukla versus Gauri Dutt. Do you remember? And this, in case of offer, general offer, Carlin versus Carbolic Smoke Ball Company. Do you remember? Now, can offer be conditional? Yes. May be conditional or must be conditional? Guys, may be conditional or must be conditional? May be conditional or must be conditional? Exactly. Offer may be conditional. Okay. So because offer may be conditional, I am giving you the next answer. Next question, give me the answer. A tells B, I want to sell you my horse. And if you keep quiet, I will assume that you will be purchasing my horse. I repeat again, you tell me I want to sell you my horse. And if you keep quiet, I will mean that you want to purchase my horse. Is this a valid offer? Is this a valid offer? No. Why not? Why not? No, it's not a valid offer. Why not? Because it can be conditional, but it cannot be. This is like forcing your offer, right? This is like forcing your offer. Now, I have a question. So because I cannot, my silence cannot be treated as acceptance, right? Silence is not acceptance. So on this, I'm going to give you a question, and you will tell me which provision will you write. If you don't reply, I will deem that you have accepted my offer. Bolo. Tell me. What will be the provision? I will deem that you have accepted my offer. Tell me, what will be the provision here? Okay. I want this answer from everyone. Everyone sitting here will be answering this question only, then I'll give the answer. Okay. So I've got three provisions here. One provision I got is mere silence is not acceptance. Okay. Second, I got offer may be conditional. And third, I got must not contain a term the non-compliance of which would amount to acceptance. Okay. First of all, if you are saying may be conditional, that means you are saying this offer is valid. But this offer is not valid, so this cannot be the answer. If mere silence is not acceptance, here, did they ask you, is there a valid contract or anything like that? Is the question asked from the side of B? No. There is no contract here. You would have given silence is not acceptance. If that was the angle, if they would have said B remains silent, is it a valid contract? Then you would have given mere silence is not acceptance. But that's not what they are asking you. They are just saying that A makes an offer to B. If you don't, nothing else is given. It is you will write about the offer is not valid. Please, you have to understand what is the question asking you. Right? What is the question asking you? You are talking about acceptance, but the question is from the angle of offer. So you have to be very careful what you are writing. Did you understand what I am trying to tell you? Did you understand what I just explained to you? So you have to understand what the question is asking you. Now, obviously they ask a lot of questions from this topic they used to ask. An invitation to offer is not. Prospectus issue, price tax, price list, auction sale, discount sales. All of this is considered as what? Sell service shops. All of this is considered as invitation. Now, what is acceptance? When I make an offer to you and you give me your consent to that offer, it's acceptance. And the person to whom the offer is made signifies his consent there. Just like offer, even acceptance has certain legal rules. First, acceptance must be unconditional. If you make a conditional acceptance, you are making a counter offer, and counter offer is not valid. So acceptance must be unconditional. Second, it must be communicated to the offerer. On this again, is the offeree required to communicate directly, or can the offeree use someone to communicate? Is there a voice issue? Can use someone. Exactly. Exactly. It's not necessary that you have to directly communicate. You can use someone else to communicate the offer. Is there a voice issue, guys? Then, is silence acceptance? No. So that Hasi to Fasi is never fussy, okay? And can if the offerer does not specify a mode for acceptance, it can be in any mode. But if the offerer specifies that I want your acceptance only in this mode, then if the offeree accepts, it has to be in that mode only. So it must be in the mode prescribed if it is prescribed. If no mode is prescribed, then it can be in any reasonable mode. But if mode is prescribed, must be in that mode. If it is not in that mode, if it is not in the mode and the other party accepts it, tell me what will happen. Is it valid? Okay. Guys, bolo jaldi. If he accepts it, then it is a valid contract. Yes. If it is not in the prescribed mode, but still the other party accepts it, then it's a valid contract. Then again, it must be within the time specified, and if no time is specified within a reasonable time. What is reasonable? I don't have any definition to the word reasonable, but yes, depends on the situation of each and every case. And the last one, can be instead of by my words, can I accept it by actions? Yes. For example, fall of hammer. It is an acceptance of the offer. Now moving forward, communication and perhaps did you understand why it is valid? Now, if I talk about communication of offer and communication of acceptance, okay, both communication of offer or communication of acceptance takes place when it comes to the knowledge of the person to whom it is made. So if I'm making it to you, when you get to know about it, it's valid. When you're making it to me, when I come to know, it's valid. But if I say communication of offer for me when I post it for you when you receive it. Simple. I post done for me, you post, do you receive done for you. Acceptance, now you will give your acceptance. Acceptance is just the opposite. For me when you post it, for you when I receive it. So let us say A sent a letter to B. A posted it on the 10th, B received on the 14th. B accepted on the 18th and was received by A on the 24th. Acceptance by conduct, fall of the hammer. I don't say by my words, but the act of falling the hammer is what? Acceptance by conduct. Rakshita, I hope it's clear. Now tell me, communication of offer for A, for B, communication of acceptance for A, for B. Offer for A when A posts it, for B when B receives it. Acceptance is opposite. For A when B posts it, for B when A receives it. Sanmo, did you understand? Did you understand it? Okay. Now, can I cancel my offer or acceptance? Yes. But obviously, just like offer or acceptance has to be communicated, even revocation must be communicated. When does communication of revocation take place? For me, when I post it, for you when you receive it. Vice versa, if you are revoking it, for you when you post it, for me when I receive it. Right? Simple it is. I post done for me, you receive done for you. You post done for you, I receive done for me. Now, what is the time for revocation? Offer can be revoked before the acceptance letter is posted. Offer can be revoked before the acceptance letter is posted. Here, if you see, acceptance letter is posted on the 18th. If before 18th you revoke the offer, it's valid. That means if till the time I don't post my letter of acceptance, if I receive the letter of revocation, then letter of revocation is valid. But once I posted my letter of acceptance, then I cannot revoke the acceptance and then revocation is not valid. Again, when we talk about acceptance, acceptance can be revoked if the revocation letter reaches before the acceptance letter reaches. That means on the 24th, the acceptance letter reaches. Before the letter reaches, if the revocation is received, the revocation is valid. But once the letter reaches, the revocation is not valid. If on the 24th we get both the letters together, then revocation is absolute. Everyone is having a voice issue. Is everyone having a voice issue? If both the letters are received together, is it fine now? Is it fine now? Is it fine now? Now is it fine? No, they have specifically given the revocation is absolute. Okay. They have specifically given if both the letters are received together, the revocation is absolute. That's it. It's given very specifically the revocation is absolute. Okay. So is it clear to all of you? Can we go forward? Sure. With this, we are done with this unit. Anyone has any doubt in this? I'm giving you a minute. You have any doubt, you ask me. Now, Acha, before I give you a minute, tell me, now does Indian Contract Act look a little easier? Now, does the Indian Contract Act look a little easier? Energy now, guys. Yesterday you had more energy. Now does the Indian Contract Act look a little easier? You will do what? So what you will do is, you will, after the video is over today, the next 2-3 days, whatever, before your economics, try to finish off as much as you can in Indian Contract Act. Again, try to finish as much as you can for Indian Contract Act. At least it will be very easy for you. You will remember it, it will be easy for you. And if you feel this video is helping, it is clearing everything, then go and like the video. Revocation. Offer can be revoked before acceptance letter is posted. Once acceptance letter is posted, acceptance is valid, you cannot revoke it. So before 18, you can revoke the offer. Right? If acceptance letter is received, once the acceptance letter is received, acceptance is valid now, you cannot revoke your acceptance. So acceptance can be revoked. Acceptance can be revoked even only before the acceptance letter is received, not beyond that. I hope it's clear to all of you. Yes, I'm just giving you a minute. Recollect whatever doubts you have, anything. Otherwise, we'll move forward. Yes. You couldn't have put it in a better way. Absolutely correct, Prats. That is the whole logic. The moment you start doubting after writing, I will come to know. There only the first doubt starts. What? Why are you doubting? There is nothing to know. You are going to rock your paper and that's an You know, that goes without saying, without any doubt, right? So can I go forward? Hello guys, can I go forward? Can I go forward? So consideration, technically known as quid pro quo. And what is quid pro quo? Something in return. It's not anything or everything in return, it's something in return. That means what? When I give you something, I should get something in return. And what I get in return is my consideration. Oh, acha. Contract Act is actually chill. I don't know why it's huge. I will not deny that. But it's actually very easy. You cannot deny that. Okay. So moving forward, what is consideration? Guys, try to recall the definition with me. When at the desire of the promiser, the promisee or any other person has done or abstained from doing, does or abstains from doing, or will do or abstain from doing, then each act or abstinence form consideration for each other. Correct? So what are the rules for consideration? First and foremost, consideration must move at the desire of the promiser. If I am doing the work for you, but you have not asked me to do the work, is it a valid consideration? Can I ask you for consideration? I repeat again, I do the work for you, but you never asked me to do the work. Can I ask you for consideration? You have asked me to do the work, but you have never asked me to do the work, but I do the work for you. Can I ask for consideration? Ask for consideration. No, because you never asked me to do the work. That means what? Unless the desire of the promiser is there, even if the promisee does the work, the promiser is not liable to pay consideration. However, instead of the promisee, if any third party gives the consideration, it's valid. The whole point is consideration must be present. It's absolutely irrelevant who gives the consideration. So if you remember, the name of the case was Chinnaya versus Ramaya, where the mother tells her daughter to pay her uncle. She goes and promises her uncle that I will pay you. Is the daughter liable to pay the uncle? No. Why is the daughter not liable to pay the uncle? Why is the daughter not liable to pay the uncle? Because why is the daughter liable to pay the uncle? Because even if the uncle is not paying any consideration, the mother had given her consideration. The mother had given her consideration. Now, consideration may be executed or executory. What is executed? It's an act which is already done. And what is executory? It's an act yet to be done. That is, there is exchange of promises, but it is yet to be performed. Then next is maybe past, present, or future. What is past? I have asked you to do the work, and after the work is done, I promise to pay you. Previous request, subsequent promise. What is future? Present, which is going on. What is future will be done. Then there should be a give and take, but there is no rule that give and take should be equal. So give and take need not be adequate. That means consideration need not be adequate. Then if a person is already receiving a legal fee for doing a particular work, and for that same work he claims something extra, that extra is what? Void. So consideration must be something which a promiser is not already bound to do. If I'm already bound to do something and I'm paid consideration for that, it's not valid. I say, yo, syllabus I will do, but marathon pay me extra. Are you liable to pay me extra for what joy? Right? For what joy? So consideration must be something which a promiser is not already bound to do. Then consideration must not be illusionary. Consideration must not be, it must be real, it should not be illusionary, and must not be unlawful, illegal, or against public policy. Right? So with this, we are done with the rules of consideration. The next is privity of contract. What does privity of contract say? Only the parties to the contract can sue and be sued. Third party cannot sue. So a third party has no right to enforce the contract. लेकिन law में क्या होता है? I want to see that from all of you. All of you that are sleeping. Early in the morning, half the class looks like sleeping only. No, nothing. Yes, no लिखने में भी मर रहे हो एकदम सब. law में क्या होता है? Exactly. Law में क्या होता है? लोचा. So there are cases where a third party can sue. There are cases. One more thing. Whenever you get a question which is a locha to a rule, okay? And if it's a 3-4 marks answer or more, then first always write the general rule and then write the locha. I hope it's clear to all of you. Whenever the question ka answer is based on a locha, it is a rule of locha, then in that case first write the general rule and after that write the locha. Okay? So trust or beneficiary. If you are a beneficiary of a trust agreement, even though you are not a part of the contract, can you enforce the contract? Yes. In case of a family or a marriage settlement, if the settlement makes someone the beneficiary of the contract, even if the party is not a party to the contract, the beneficiary can enforce the contract. But for family or marriage settlement, no, the contracts have to be in writing. Assignment. When the rights of a contract are assigned to a third party, I repeat again, when the rights of a contract are assigned to a third party, even if the third party is not a party to the contract, he can still enforce the contract. Then estoppel or covenants running with the land. If a third party acknowledges his liability to a party to the contract, even though there is no contract between the party and the third party, but still the third party can be sued for that benefit. For example, in case of Amazon and you have placed order with Amazon. Blue Dart acknowledges they are holding the goods for you. Now you can sue Blue Dart even though you and Blue Dart have no contract. The last one, in case of covenants running with the land, if the purchaser of a land purchases a land which he knows is bound by conditions, even he is bound by those conditions. The next one, no consideration, no contract. The general rule is the contract without consideration is void. Right? General rule is contract without consideration is void. लेकिन लॉ में क्या होता है? लोचा. So there are a few cases where without consideration it's valid. First, if the contract is made out of love, natural love and affection, there are 4 points here, and only when all the 4 points are present, the contract is valid. First, contract is made out of love and affection. Contract is made between parties who stand in a near relation. The contract is written and registered. It's a valid contract. Right? It's a valid contract. Second, compensation for past voluntary service. From the name only we get it. The services were rendered voluntarily. The services have already been rendered. Promiser promises to compensate. Good, Rajnikant, you pointed out to him. He forgot the school class rules, right? So in that case, it's a valid contract. What is the time bar debt? If for 3 years the debtor does not take any steps to recover to pay the money, or the creditor does not take any steps to recover the money, then after 3 years it becomes time barred. That is, it becomes irrecoverable by law. It becomes what? Irrecoverable by law. Now, if the debtor or his agent authorized by him, if they give a written promise to pay a time-barred debt, it's a valid contract. Completed gifts. Just a promise to give gift is not enforceable, but if the other party is given the gift, it becomes a valid contract. Charities and donations, promise to give charity is not enforceable, but if the other party has incurred any liability, then it is enforceable to the extent of liability incurred. And bailment and agency, in these 2 cases, we'll do it when we do special contracts. Consideration is not needed. With this, we are done with this unit. This unit is small, easy, because next unit is like, okay, bar of all units, so we need to pay attention very much there. Till this point, is it clear to all of you? If you have any doubt, you ask me, otherwise we'll move forward. Then you are liable to pay quasi contract. We'll do the same thing in quasi contract. I'll explain that concept in detail. Okay, I'll go to the trust or beneficiary part again. A father, along with his lawyer, created a trust in favor of his son. Basically, father put all his property in the trust, appointed the lawyer to take care of the property for his son in case the father dies. The son did not get the benefits. Can he sue this contract? The son did not get the benefits of the trust. Can he sue the contract? So when you are named as the beneficiary of a trust agreement, you can enforce the contract. A has to pay B 10,000. B says, don't pay me, pay it to C. If C does not get the money, can C sue the contract? If C does not get the money, C can sue the contract. Chalo, can we go forward? Anything else? So moving on, okay, this chapter, this unit rather, it's a huge unit, there are a few things. So I will explain, you please if you have doubts you ask me, otherwise a little explaining here and there I'll try and do it, okay? So what do I mean by capacity? Ability to contract. That is ability to decide whether to contract or not. Who is capable of contracting? A major, a person of a sound mind, and a person not disqualified by law. So who is not capable of contracting? Who is not capable of contracting? A minor, a person of an unsound mind, and a person disqualified by law is not capable of contracting. And if they make a contract, a minor or a person of an unsound mind or a person who is disqualified by law, if they make a contract, such contract is what? Void. Who is disqualified by law? Insolvents, alien enemy, convicted criminals, foreign sovereigns, or company against its MOA. This we already did yesterday. Against its MOA, ultra wires, beyond the powers of the company. And such contract is what? Who is a person of an unsound mind? A lunatic. Then a person who is under the influence of drugs or alcohol. Or a person who is in a delirious state of mind. Delirious means not in a complete sane state of mind due to illness. That is, he is not completely dead, but he is not alive. So if they make a contract, contract is void. Guys, tell me, if a person has periods of sanity and insanity, if a person has periods of sanity and insanity, what will happen to the contracts during periods of sanity? And what will happen during periods of insanity contracts? Periods of sanity is what? And insanity? And insanity? Insanity. So we are done with this. Can I go forward? Yes. Now, an agreement with the minor is void ab initio. That means we cannot sue a minor. That means cannot sue a minor. But a minor can be a beneficiary. That means minor can sue the other party. That means minor can sue the other party. Right? Minor can sue the other. That means in every contract, minor has to give something, minor has to get something. What the minor has to give is his liability, but what the minor has to get is his right. And if he does not get his right, can he enforce the contract? Yes. Then minor can always plead minority. So if a minor fraudulently enters into a contract and the contract is cancelled, that is, you go to the court to file a case, then in that case, can the minor go and say that, look, I am a minor? Yes. And if he proves his minority, what happens? The contract is discharged. Why? Because the contract with the minor is void. However, if the intention of the minor is to cheat, even if he proves his minority, he will have to compensate. Now, please understand, compensation can never be more amount. It will always be the same amount or less. If the minor has already spent the amount, then he will only get, if the minor has already spent the amount, that whatever he has spent on that can be claimed, but then money cannot be claimed. Is it clear to all of you? Now, when a minor's act is void ab initio, since the minor's act is void ab initio, on attaining majority, you cannot ratify the act. Can you make a new contract? Yes, but you cannot ratify the old contracts. Again, if the guardian of a minor makes a contract on behalf of the minor, is it valid? If it is beneficial for the minor, it is valid. Now, if he makes a contract for movable property, buy or sell, valid. If it is immovable property, purchase is not valid, sale is valid. Now, when a minor is supplied with necessaries, let's please understand necessaries is something which is necessary for his station in life. Necessary for his station in life, and he must not be in possession of them. Now, I want you to listen very carefully. If the goods supplied to the minor are necessaries, or if the goods supplied to the minor are not necessaries, guys, tell me one thing. If it is not necessaries, is anyone liable? No. Neither the minor nor his property is liable. But now supplier, it cannot do anything. Minor, he will not get his money back. But if the goods supplied is necessaries, there is a liability. But is the minor personally liable? No. The liability is against his property. That means if the minor has property, the supplier will get the money from his property. If the minor has no property, supplier will not get back anything. I hope it's clear to all of you. Then a minor, he cannot be a partner in a firm, but he can be a beneficiary. Can he be an agent? Yes, but not a principal. Any contract that he makes as an agent is valid, yes. But if he is the principal, if the minor is the principal, then who will be liable? Agent is personally liable. Correct? Can a minor be declared insolvent? Insolvency is when your assets are more than your liability, less than your liability. He has no liability. What insolvent? So minor cannot be declared insolvent. Then the rule of estoppel does not apply on a minor because he can always plead minority. Even saying I'm a major, he can later go and say I'm sorry, I'm just a minor. So rule of estoppel does not apply on a minor. But if his intention is to cheat, he will have to compensate. So a minor is liable for torts, but he is not liable for breach of contract. That means what? If he has committed a tort, he says I'm a major and then makes a contract, that he is liable for. But when the other party knows he's a minor and makes a contract, then he cannot sue the minor for not performing. Then a minor can be a joint promisor. But if he is a joint promisor, he is not liable, except him, all others will be liable. He cannot be a shareholder of the company because when the company allots shares, it is a contract. But he can get the shares by way of transfer or transmission only if the shares are fully paid up. Because if the shares are fully paid up, we don't have to take money from him. Then, if any person has given a guarantee on behalf of the minor, he will be liable personally. That means the creditor can directly go to the surety for the money, and once the surety pays the creditor, he cannot recover the money back from the minor. Parent of a minor shall also be liable for his acts only when he acts as an agent for the parent under their authority. That means what? Minors' parents are liable only when they have given an authority to the minor to contract in their name. If authority is not given and the minor makes a contract saying my parents are liable, the parents will not be liable. Is it clear to all of you? Clear to all of you? With this, we are done with minors concept. We are done with capacity. Tell me if you have any doubts, otherwise we'll move forward. You take a loan and then you want to cancel the contract. And then you go and say, I'm a minor, so I'm not liable to pay. First, you cheated. Then you cancel the contract. That means your intention is to cheat. Even if you prove your minority, you will have to compensate the others. Which is it clear? Specific performance is what, Rajnikant? What is specific performance? If you remember, we have done it. So if I explain it to you now, you will not understand. But once we do specific performance and then I'll explain it, then you will be able to understand. That's the reason I did that. Okay, I'll just get water for myself. If you have any doubts, you just jot down your doubts here. I'll just be back. So we are back. If minor commits a tort, then his liability is against the property, right? His liability is against the money he has taken, or if he has purchased anything from that money, it is against, in that case, it will be only against what you say. If he has already purchased, as I told you, then it will be against whatever he whatever he has purchased. Like the laptop or example, if you remember, he purchased the laptop, so the liability is only up to the laptop. Can I go forward, guys? Can we go forward? Yes. Jyoti, did you understand? Let's say he took a loan of 20,000. That money is remaining. We will ask him to pay the money. Let's say he utilized the money and purchased a property of 15,000, 5,000 he just spent off. 15,000 ka property that he purchased, we can take it, and the rest of the money which he spent off, we will not get. That's it. Clear? Can I go forward? Okay, free consent. When we talk about free consent, in every contract, consent obviously has to be present. The consent must be given by choice, right? Consent must be given by choice. When is the consent not free? If the consent is given by coercion, undue influence, fraud, misrepresentation, or mistake. Coercion, undue influence, fraud, misrepresentation. Contract is what? Voidable. Mistake can be mistake of fact, or it can be mistake of law. Of fact can be bilateral or unilateral. Of law can be Indian or foreign. Unilateral mistake and Indian law is valid. Bilateral mistake and foreign law is void. Right? Isn't it? Can we go forward? Coercion. Remember? Tell me the bite for 2000, otherwise नहीं पे टपका दूंगा. Remember that? Yes? That is coercion. What is coercion? Threatening to commit a crime to force the other party to enter a contract, or the unlawful detaining of the property of another. And again, threatening to commit a crime or the unlawful detaining of the property of another. Yes, Munna bhai, correct. The force is a physical force and can be by or on a third party. What is undue influence? The parties stand in a relationship. Relationship can be real, apparent, or fiduciary. And one party has a dominating position, forces the other to make a contract on terms which are unreasonable. It is what? Undue influence. The force is a mental or a moral force and can be only on the parties. How can I know that the position is a dominating position? If the parties are in a real or apparent relationship, or if the parties are in a fiduciary relationship, or that there is one of the parties is under mental distress, or the terms of the contract are unreasonable. Tell me, did you understand till this? Yes? Can we go forward? What is fraud? Suggestion of a fact which is not true and the person believes it not to be true. That means I make a statement, I know it's not true, and I tell you that this is true, but I know it's not true. Intention to deceive. In some cases, it is your duty to speak up. Then you keep quiet. It's fraud. So active concealment of facts, where you knowingly hide the facts of the contract. Third, promise made without an intention to perform. So there are three things. I make a wrong statement, I don't say something, or I make a contract without an intention to perform. The fourth one, any act declared fraudulent by law. Any act declared fraudulent by law, right? So, what are the characteristics? And last one, any act to deceive. That means any act which is done with the motive to deceive. So, what are the characteristics of fraud? First, there is a representation. Second, the representation is false. Third, representation relates to material fact. Fourth, it misleads the other party to contract. Fifth, having contracted, the person suffers a loss. It is misrepresentation. When it's fraud. When I say fraud, aggrieved party can cancel or accept, but the other party has no option. That means the contract is voidable. That means what? The contract is voidable. I go to shop, I see a painting, I believe it's made by Picasso, I purchase it. Guys, you will tell me the answer. I go to a shop, I see a painting, I believe it's made by Picasso, I purchase it. Bolo. Can I return the painting back? Not fraud. Okay. Can you return it? No. So silence is not fraud. That means what? The contract is valid. That means what? You cannot cancel the contract. Right? That means you cannot. लेकिन law में क्या होता है? लोचा. So there are cases where silence is considered as fraud. First one, where it is the duty of the person keeping silent to speak. That means normally the person is not required to speak, but there is a special situation which demands he should speak. In that case, if he is silent, silence is fraud. When it is the duty of the person keeping silent to speak. Now, when is it the duty of the person keeping silent to speak? If it relates to immovable property, insurance contract, marriage contracts, family contracts, prospectus contracts, and contracts which are based on fiduciary relation. Here, silence is fraud. In all of these cases, silence is fraud. That means aggrieved party can cancel the contract. Can I say in these cases, active concealment of fact happens? Can I say in all of these cases, it is active concealment of facts? Please keep the books open. Whenever you are getting anything, please make a note of it. Is it clear to all of you? Hello, hello, hello. Hello, hello. Active concealment of fact means when you knowingly hide the facts. When it is your duty to speak but you don't speak. When it is your duty to speak but you don't speak. Is it clear to all of you? When it is your duty to speak but you don't speak. Is it clear? हो गया guys? Yes. And when silence equals to speech. What is this silence equals to speech? You go to the shop, you see a painting, you tell the shopkeeper, I want to purchase this Picasso's painting. He says, I'll get it back. When he does not say it's not made by Picasso, that means he agrees it's made by Picasso. Their silence is what? Their silence is fraud. I hope it's clear to all of you. What is misrepresentation? There is a statement of fact which is not true, but the other person believes it's true. Breach of duty without an intention to deceive. That means the intention is not to deceive. Gains an advantage over the other person. That means without a motive to cheat, I'm gaining advantage over the other person. Causing, however, innocently. Because it's however innocently. Because it's innocently, that means it's without an intention to deceive. A party to make a mistake as to the subject matter. Just because I've used the word mistake doesn't mean it's a mistake. Just because I've used the word mistake, it doesn't mean it's a mistake. So, now moving forward, what are the consequences? Okay, what are the consequences of coercion, undue influence, fraud, misrepresentation? In all the four cases, the contract is voidable. That means if I want, I can cancel. If I want, I can accept. Now, please always remember, in fraud, one additional thing is there. Apart from being voidable, I also have a right to claim damages. But in misrepresentation, I can cancel the contract, but I cannot claim the damages. Now, if one party uses fraud or misrepresentation, but the other party, if he would have used his diligence, would have come to know the facts, the contract is valid. Ma'am, like this, so I can know, using my diligence, I can come to know the facts in every case. I agree. So please, I'm not talking about every case. When the question tells you you had means to discover the fact, only then this concept applies. When the question tells you you had means to discover the fact, only then this case applies. So otherwise, in every case you can use your diligence. Where in a contract there is an option of using the diligence and you don't, then it is, you have no remedies, the contract is valid. That means what? It means the aggrieved party cannot cancel the. One party is using fraud, but that fraud must influence you to contract. Well, I'm using fraud, but you are not influenced by that fraud. That's not fraud. Fraud must induce you to contract. So I have used fraud, but you are not misled only by it. Then it is not fraud. It is absolutely valid. The contract is not induced by fraud. The contract is absolutely valid. Now, mistake of fact. When we say mistake of fact, fact means the subject matter, the essential fact. What kind of mistake can I make about the essential fact? It can be a mistake of identity, existence, quantity. It could be anything. Both are mistaken. So you will, whether it is misrepresentation, fraud, or bilateral mistake, it will be decided from the terms of the agreement. So from the question, so you have to identify from the question what it is. Now, when we talk about bilateral mistake, the contract is void. But if it is a bilateral mistake of price, the contract is valid. On the other hand, unilateral mistake, no remedies, the contract is valid. Now, sometimes they might ask you, A goes to the shop, sees a painting, believing it's made by a famous artist, purchases it. Later he comes to know it's a copy. You will answer this question. A goes to the shop, sees a painting, believing it's made by a famous artist, purchases it. Later he comes to know it's a copy. So he wants to return the painting back. On the grounds of fraud, can he cancel the contract? What provisions will you write here? Tell me guys, what provisions will you write here? Cannot cancel, I get it, but provisions I'm asking you. And that is what happens when you don't listen the question to the question carefully. I said A goes to the shop, sees a painting, believing it's made by a famous artist, purchases it. Later he comes to know it's a copy and he wants to cancel the contract on the grounds of fraud. I mentioned that. On the grounds of fraud. Those who are like, no ma'am, you never mentioned. Please go back, scroll back and see. Yes, silence is not fraud is what your answer should be. I think you want to cancel it on the grounds of fraud. So please, your question is only giving you the answer. Your question is giving you the answer. Got my point, guys? Silence is not fraud. So that will be the provision here. Clear? Anyway, unilateral mistake contract is valid. As a citizen of the country, it is my duty to know the laws. If I don't know the laws, the contract is, you have no remedies. The contract is valid. Ignorantia juris non excusat. But foreign law is not a law in my country. So foreign law ka mistake is treated as a mistake of fact and the contract is valid. Sorry, contract is. Is it clear to all of you? With this, we are done with. I think this was one topic where everyone had a lot of doubt, and that is the reason I added these things. The grief party cannot cancel the contract because this is when we were discussing or when people were asking me the doubt. This is what I realized people were having doubts in. So, guys, tell me, is it clear to all of you? Anyone has any doubt, please ask me first and then we'll move forward. We have covered quite a good content also since morning. We have, not. I hope the speed was okay with everyone. I did not go too fast also. Consideration is important. Mistake of price is not a mistake of essential fact. Mistake of price. Lohita, you only tell me. Lohit, as per you, you only tell me. The more you will solve questions, the more you answer questions, no, the clarity, conceptual clarity is better. So whenever I ask a question, everyone should be answering. Look, you only tell me what you think. Can you mention both? Can you make a reference to both? Yes, yes, you can make a mention to both. Even in that example that I gave you, you can write silence is not fraud. Sorry, unilateral mistake. But they are asking you on the basis of fraud. So silence is not fraud, has to be there. You can add unilateral mistake. You can add that. But the answer basis has to be silence is not fraud because the question is saying answer as per fraud. Is it clear? Can we go forward? Yes. So now starting with the next essential, which is lawful object. Object means the purpose for which the contract is made. And this purpose must be what? Lawful. If the purpose is unlawful, the contract is what? Void. If the purpose is unlawful, the contract is what? Void. What is unlawful? What is lawful? For that we will study unlawful, the rest is automatically lawful. The first and foremost, if it defeats the law. That means you go against the law either directly or indirectly. You go against the law either directly or indirectly. Directly you go against the law, defeats the law. Indirectly you go against the law provisions, defeats the provisions of the law. The next one is if the agreement is fraudulent. In that case, we had discussed, if you remember, agent acts outside his authority. Remember, the agent acts outside his authority. Correct? Injury to a person or his property. Any agreement which causes injury to a person or his property. Injury can be a mental injury or a physical injury. For 100 rupees work for you for 3 years physical. If I don't 100% rate of interest per day, mental injury. Then the agreement is what? Immoral. There are certain social laws, no? So that is what? Immoral. And the last one, agreements against public policy. See, public policies are made for the public. So being a part of the public, it is my duty. I should follow these policies. If I go against these policies, it's what? Void. Okay, guys. And the last one, obviously against public policy has a lot of heads in it. Before I move forward, you have to make a promise to me. Now, so if you are ready to make a promise, I'll talk to you about the promise and then we will proceed. Otherwise, you can leave the session. So, are you ready to make a promise to me? Chalo. Tell me. I have a lot of promises to take from you. Okay. Only you have told Rajnikant yes. Let others also say yes. Then I. First and foremost, while you are studying, again, first and foremost, while you are studying, I want this promise from you that you will not study law with the mindset that it's a tough paper. You will study like it's like every other paper, economics, accounts, QA, just like that you will study law. First, I want that promise. Tell me, yes, do you promise? I'm teaching like there are almost 64, 65 people attending the session, but I'm only getting answers from 10 of you, not even 10. So Rajnikant, you will accept, chalo, your acceptance, yes, आगे बोलो, लोग, दूसरे लोग बोलो. ठीक है. My second promise, when you go go to write the paper, I don't want you to be overconfident, but I don't want you to be underconfident. Oh my God, I don't know anything in law. I don't know ye paper I'm going to not clear. I want you to make a promise to me that no ma'am, whatever, I will go with confidence that yes, I can ace my paper. So this is my second promise that I want from you. So this is my second promise. Rajnikant ka promise is already there, so I don't ask him. Okay. Okay. Third, at this point of time now, no one will have this thought that should I write in September or should I go for Jan? You should go and write your exams in September. Irrespective of how any paper goes, you will complete all the 4 papers. Yes? Okay. And the last one, this is the most important one. I will not give up on my social life, but I will restrict everything else and give my 100% priority. Exactly, this is what I want to see. Okay? I will not give up my social life. I'm not saying 24/7 just study. I'm not saying that. But right now, my restricted, that will be only maybe 10 minutes in a day. I will not be using my social media or my phone. The main concentration will be on studies, and in no way I am compromising with my study. And dedicatedly every day, whether it's Sunday, whether it's my birthday, mom's birthday, ma'am's birthday, whoever's, I am going to sit and study. This is the last one that I want. Because these are the 4 things. Whenever you feel like I don't know, remember, go and come back and watch this video again and go to your studies again. Okay? So can I start? Can I move forward now? Can we move forward, guys? Yes? If you don't know what to study, make a plan. I start from here. That's the best start to your studies. Okay? So I want everyone's attention here. Come back here, all of you. So the first one, agreements against public policy, the first one. So I'm happy to see all of you have the josh to say yes. Trading with enemy. My country is at war with another country, and during war I make a contract with my enemy. Right? During war I make a contract with the alien enemy. It's obviously void, not just void, it's illegal also. Stifling prosecution. Settling with fine instead of imprisonment. A person has committed an offense where imprisonment is mandatory, but no, nothing doing. That should keep coming from us to you all. So a person has committed a crime for which we should imprison him, but we are like, nothing doing, bro, go. I will leave you, give me money, go enjoy money. Tomorrow come and do that crime with me money. Huh? So a punishment should be by way of fine, but we settle with the should be by way of imprisonment, we settle with a fine. This is stifling prosecution and hence it is void. Champerty and maintenance. In both the cases, we help the other party to file a litigation. And when you share the result of the litigation is champerty. When you do not share the result of the litigation, it is maintenance, right? Then sale of public offices. Interference with the course of justice, going in the same order as we have it in our book so that it's easier for you to follow. What is interference with the course of justice? You are bribing the witnesses You are bribing the witness of a case, or you are tampering with the evidences. You tear off the page, you remove the recording. This is tampering with the evidences. Okay. Then sale of public office. What is sale of public office? You bribe for a public post or public recognition, like for example Padma Bhushan, right? Or you pay to public employee to retire before his term so that you can get that job. That is what? Sale of public offices, right? Then interest against obligation. You want a favor from someone and you pay for that favor. Favors don't come free of cost, right? So you pay for that favor. That is what? Interest against obligation. Marriage brokerage contract. I make the, I get two people married. Like get matlab, I make sure that their match happens. But if you just give an information of a prospective groom or bride, that is not marriage brokerage contract. Marriage brokerage is like I'm fixing the marriage, right? Marriage brokerage is what? Fixing marriage of a couple, of two parties. That's marriage brokerage contract. It's void. Agreement and restraint of marriage. You stop a person from getting married. It's what? Void. So what you should do now, if you are getting married, someone comes and says, I'll give you money, don't marry. Take the money, marry, use that money for your honeymoon. But to be very honest, till today I was telling all these things. But after that blue drum and God knows what, up to लगता है डर भाई सोच समझ के करना, ठीक है? So moving on to the next one, agreement and restraint of trade. See, every person has a right to carry a lawful trade, and any agreement that stops him from carrying a lawful trade is void. But Indian Contract Act and the Partnership Act lays down some lochas where I can stop a person and it's absolutely valid. The last one, agreement in restraint of legal proceedings, is void. What is that? That means you stop the other person from going to court. That's void. But if you are restricting the courts, that means you are saying we will go to this court and not to the other court. This is absolutely valid. Restricting is absolutely valid. With this, we are done with this topic. Tell me guys, any topic you want me to explain again, we'll do, otherwise we'll go forward. Is any point should I explain again? Or should we go to the next topic? Litigation means case. Litigation means case. So the last one, agreements expressly declared void. Since nothing is written here for this topic, I'll just write it here only. The first one, agreement which is expressly declared void. The first one is agreement, the meaning of which is uncertain. Now, because the meaning is uncertain, obviously the contract is what? But if I have means to discover the uncertain term, it's valid. For example, I say I will sell you 100 liters of oil. Which oil? Not valid. But if I deal only in mustard oil, it's very obvious I'm only talking about mustard oil. Then the next one is agreement has two parts, one legal and other illegal. This you will answer me what will be in this case. Agreement has two parts, one legal, other illegal. Follow. Here we have two things. The legal part may be separable or the legal part may be not separable, right? If they are separable, legal is valid, illegal is void. If they are not separable, it's completely void, right? The third one is, yes, wager. What is wager? Betting. What is wager? Betting. Game of chance. An agreement to give money or money's worth on the happening or non-happening of a future uncertain event. Now, so basically it is what are the essentials of wager? To give money or money's worth. The event is the sole determining factor of a wager. Both the parties are set to win or lose. And tell me one thing, guys. In that rain, okay, I will give you money if it rains, you give me money if it does not rain. Do you or do I have any personal interest in the rain? You or I, do we have any personal interest in the rain? Exactly, we don't have any personal interest in the rain. So we don't have any interest in the event other than the stake, the money. In India, wagers are void, but in Gujarat and Maharashtra, wagers are also illegal. Right? So what are the features of wager? Dependent on uncertain event. Event is the sole determining factor. Agreement is to give money or money's worth. Right, then both parties will win or lose. And the last one is no interest in the event, only interest in stake. That means I don't have any interest if it rains or it does not rain. My only interest is in the stake. With this, we are done with this portion, one set, okay, of the whole thing. So with this, actually, Indian Contract Act can be divided into three parts. This is the first part. We are done. Essentials of valid contract. The second part is performance, and the third part is special contracts. Should we take a break? Should we take a break? You go have breakfast. Do you want a break? Should we take a break? Yeah, you are quiet, like this. So I'll give you 30 minutes break. Go have your breakfast. Aram se eat your breakfast, because after that, let's see how long we continue. But I think I won't give you a break before we finish, maybe. So I'm giving you a 30 minutes break. It's 10:05. Let's meet at 10:35. Okay? Take a 30 minutes break. I'll swim 30 minutes. you guys back? So guys, had breakfast. Breakfast today morning. We went out for breakfast today morning. So I think we will wind up by 1:30. Pawan, you study, please study smartly. If you study smart and plan properly, very easily you can clear your exam. But you have to plan it smartly. Like accounts, you have scored 43, you should score in 60s there. Okay. Let everyone join, then we'll start. Okay, so moving forward to the next unit. So now we are going to the second part of the Indian Contract Act, which is performance of the contract. Okay. Now, when we say performance, no, performance can be actual or attempted. What is actual performance? We both have fulfilled our obligations. Today, after I finish this lecture, I'm done with my obligations today. Marathon is done, classes are done. Now, if you do anything extra, that's extra only. Okay. So, the contract is done. Attempted. We have taken the marathon. So many people have not attended. Am I under any obligation to do the marathons again? No. The marathons are done. We have already done the other party. So I have no obligation to perform. But because of that, if I suffer damages, can I claim the damages? Yes. Now, when one party is ready to perform, but the other refuses to accept, the aggrieved party has no obligation to perform but has a right to claim damages. But when is it considered that you have performed validly? If you have performed at the proper time and place, if at the time of performance you have not put in any conditions, That is, you made an unconditional performance. If you have performed the whole of the obligation and the contract relates to goods and the buyer was given the right to examine the goods, and then if the other party refuses to accept, then you have a right to claim the damages. But if these points are not fulfilled, then in that case you cannot claim any damage from the other person. Can I say attempted performance is nothing but effect of refusal to perform? Yes. Now, who can perform the contract? The promisor can perform the contract. The agent can perform the contract. Then, in case of death, legal heirs can perform. But if the contract is based on personal skill and confidence, then only the promisor can perform. Third parties can perform, yes, and even joint promisors can perform. In case of joint promisor, the liability of the joint promisor is joint and severe. That means I'm jointly liable for my share, but I'm severely liable also for the whole share. If one of them pays on behalf of the others, he can recover from the others their respective share. If one of them is unable to pay, why would he be unable to pay? Guys, tell me. Why would he be unable to pay? Guys, tell me quickly, why would he be unable to pay? Yes, insolvency. Then in that case, his loss shall be borne by the others in their proportion. In that, if he is unable to pay, then his loss shall be borne by the others in their proportion. If any one of the legal heirs is swaha, then his legal heirs, if any one of the joint promisor is swaha, his legal heirs will be liable to perform. But always remember, first, legal heirs have no personal liability. Second, legal heirs are only liable for their share, not for the other's share. And if the promisee releases any one of the joint promisor, he shall be liable to the others, and the others will be liable to the promisee. So basically, let's say ABC promised to pay D. D releases A. B and C will be liable to D, and A will be liable to B and C. So basically, D ne release karke he became good, but nothing actually happened. So D will sit and after saying you don't have to pay, D will sit and say isme mera ghata, mera kuch nahi jata, right? So basically, at the end of the day, A continues to be liable. Now, what is succession? Inheritance, what is assignment, transfer of rights? Succession takes place by operation of law, whereas assignment can take place either by operation of law or by agreement. When I talk about succession, both assets and liabilities are transferred, but liability only to the extent of assets inherited. But when we talk about assignment, liabilities can be transferred only when all the parties agree to such transfer. Now, time and place of performance. If no time is given, it should be performed within a reasonable time. If day is given but no time is given during the business hours. If no place is given, duty of the promisor to ask the promisee to fix a reasonable place. Now see, if I do sale of goods act, in sale of goods act, if no place is given, the place at which the goods were at the time of sale or at the time of agreement to sell, right? Whereas here, what they are saying is, if no place is given, duty of the promisor to ask the promisee to fix a reasonable place. So see guys, you can see what difference there is, right? So if you write as per Sale of Goods Act, the answer is different. If you write as per Indian Contract Act, the answer is different. Correct? If I have to perform on a particular day, but the contract says that you will ask me and only then I will perform. It is your duty to ask me to perform. Now, type of performance. Type of performance in some cases can be of essence, whereas in other cases it may be not of essence. If the time is of essence and you fail to perform within the time, the contract is voidable. That means you can cancel or you can accept. Seriously, Rajnika, my hair is not airing. So if you cancel, can you also claim the damages? Yes. But if you accept, you cannot claim the damages unless it's mentioned. On the other hand, if the time is not of essence and you fail to perform within time, the contract is valid, but you can claim the damages. And now you will tell me time of delivery. Yesterday only we did, and time of payment of essence or not of essence. So jaldi say of essence or not of essence. Exactly. Time of delivery is of essence, whereas time of payment is not of essence, right? Time of delivery is of essence, whereas time of payment is not of essence. Can we go forward? Can I make time of payment of essence? Can I make time of payment of essence? Yes, by specific words I can do that. So, can we go forward? Appropriation of payment. Always remember there are several distinct debt. Okay? When appropriation payment of yes should be mentioned in the contract. Several distinct appropriation of payment. What is happening? Several distinct debts, and the debtor makes a part payment. Right? Debtor makes a part payment. There are several means multiple. Distinct means I can distinguish one from the other. I repeat again, there are several distinct debts. Several means multiple. Distinct means I can distinguish one from the other. There are several distinct debts and the debtor makes a part payment. Against which debt we will adjust this payment is known as appropriation of payment. I repeat again, against which debt we will adjust this payment is known as appropriation of payment. Now, when the debtor is making the payment, first right, who has the first choice to decide? Debtor. So when the debtor makes the payment, can he specify, I want you to set off this debt? Yes. And if he specifies, only that debt has to be set off if the creditor accepts the money. Now see, how can you specify? You can say by words, I want you to set off this debt. On the other hand, if you make a payment which is an exact replica of the debt, if you make a payment which is an exact replica of a debt, then it is implied that I want you to set off this debt. Okay? Now, if the debtor does not specify anything, he just makes the payment on account generally. What is this on account generally? Against my account, take this money. Then in that case, can the creditor set off any debt? Yes, he can even set off a time bar debt, but he cannot set off a disputed debt. Now, if both the parties do not specify, then in that case, first in, first out. But guys, I have full faith on you. Law says first in, first out. My students will say first in, fastest out. That is how we work. First in, fastest out. Right? Like everything since morning, going in, but going out faster. You know, multiplex 4 times. So, if nothing is specified, the debt first in order of time will be set off the first. Guys, tell me, if the first debt in order of time is a time bar debt, will that also be set off? Will that also be set off? Tell me quickly. Tell me quickly. Well, yes, he can. He can say that you are supposed to pay like this, you are supposed to pay like that. He can say that. But generally, they do accept. Yes, so even in the first debt is the time bar debt. Can we set off that debt? Yes, absolutely, we can set off even that debt. Coming back to the next one, reciprocal promises, that is dependent promises, that is performance of one depends, guys. I'm asking you again on a very serious note, are you finding Indian Contract Act a little easy after this discussion? You want to give a little more detail. More detail make your it won't get over only. That is why I'm going at this pace because it's revision after all. I hope you are finding Indian Contract Act a little easier than you did before. Please solve a lot of questions. Now, reciprocal promises. What is reciprocal promises? Performance of one depends upon the performance of the other. That is, I will perform only when you perform. A will deliver only when B pays. Right? A will deliver only when B pays. So unless B pays, A is not liable to deliver. So this is known as what? Reciprocal promise. Now, how do we fix the reciprocal promises? How do I fix the reciprocal promises? It can be fixed by the parties or it can be fixed by implication. What is fixed by parties? The parties decide who will perform first and who will perform later. Excuse me. The parties decide who will perform first and who will perform later. And if we have decided that you will perform first and then I will perform or vice versa, performance has to be like that only. I repeat again, if we have decided that I will perform first and then you will perform or vice versa, then performance has to be like that only. Correct? If both, in case it may happen that we have not by specific word fixed the order, but it's evident from the contract who will perform first and who will perform later. I want you to construct my house. I will supply the material. Now, I cannot say unless I don't supply, please don't do the work. But isn't it obvious that unless I don't supply, you cannot do the work? So this is fixed how? By implication. In case of reciprocal promise, if one party prevents the other party from performing, the party prevented has no obligation to perform but has a right to claim the damages, right? If one party prevents the other from performing, the party prevented has no obligation to perform but has a right to claim the damages. Now, when we talk about reciprocal promise, tell me if one part is legal and other illegal, what will happen? If one part is legal and the other illegal, बोलो क्या होगा? बोलो चल चल. Again wrong. If it is separable, legal is valid, illegal is void. If it is not separable, contract is completely void. Now, chalo, the next one, restitution. What is restitution? To restore. Restore means to give back. The benefits received under a void contract or under a voidable contract on its becoming void. So please understand, restitution first of all is not damages, right? Restitution first of all is not damages. All of you stop replying. No one is replying basically. Yeah, same, but different. No money, no honey. Whenever you feel demotivated to study, don't feel like studying, नहीं करना है CA, remember, no money, no honey. ठीक है? The only motivation right now that a CA student needs is no money, no honey. So restitution, please remember, restitution is not damages. It is something, damages is something over and above restitution. Restitution means whatever I have paid. So if the contract is voidable and I have cancelled the contract, whatever I have paid in that contract, can I recover that? Yes, that is restitution. That is restitution. A contract has later become void. Then whatever I had given to the other person, can I claim that money back? Yes, that is restitution. Please remember, it's return of benefit. So if you give any security money or caution money or security deposit, whatever name you call, it is not considered as benefit and you cannot ask for the return of this money. Is it clear to all of you? Can we go forward? Just checking if what all are there or not. Yes, before we go forward to discharge, we have done with one part of this chapter. Unit, any doubts, ask and then we'll go forward. No doubts. The best part is we don't have only doubts. Best part. So let's go forward. All of you clear? Can we go forward? Discharge of the contract. What is discharge? Termination of the contract. That means what? Contract comes to an end. That means what? Parties are not bound under the contract. Right? That means what? Parties have no obligation to perform. Rajnikant, it's because you are attending online. No, so much you have to say, right? In face to face, I will see how many of these things will be coming. Now, moving forward, what are the cases where a contract is discharged? First, it is by performance, which can be actual or attempted. We already done. Both the parties have fulfilled their obligation. Attempted, one is ready to perform, but the other refuses to accept. Next, by lapse of time, time barred debts. Operation of law, death, insolvency, merger. When one inferior right merges into a superior right. Two contracts are there. Inferior right merges into what? superior right. The contract is discharged. How? By operation of law. A contract is made for a period of time, but before that period, the person is insolvent. Contract is discharged. Contract, if it is no, if the party is swaha, his legal heirs will perform. But if the contract is based on personal skill, legal heirs cannot perform. The contract is what? Discharged. The next one is contract is discharged by mutual consent. Don't forget, all of this four is what? Mutual consent. The first one, novation. In novation, the old contract is cancelled, and in place of the old contract, a new contract is made. This can happen between the same parties or with a third party. Then the next one is what? Rescission. Rescission is cancellation of the old contract. So basically, in novation, new contract is made. In rescission, new contract is not made. In novation, a third party can come. In rescission, a third party does not come. In rescission, rescission is a part of, novation is a part of rescission. Right? What is alteration? Change in the terms of the contract. When you change the subject matter, it is novation. But there are other subordinate terms in the contract. When you change those subordinate terms, it is what? Alteration. The last one, remission. I am making the payment. I am making a lesser payment in full satisfaction of the debt, or I am paying in kind instead of cash. This is what? Remission. Then the next one is by impossibility of performance. And when I say impossibility of performance may be existing at the time of contract, or it may be supervening impossibility. Existing at the time of contract, void ab initio, pre-contractual impossibility, subsisting impossibility. When the contract was made, it was void. No to both. Get me a star from the sky. He says, yeah, I'll get it. We both know impossible. Unknown to both. A wants to sell his horse to B. B agrees to purchase. Both A and B do not know the horse is already dead. Void. Can I also call it as bilateral mistake? Yes. Unknown to one. A knows his horse is dead. He still tells B, I want to sell you my horse. Here, what we really need to understand is that in this case, okay, known to one, this is fraud. A knows his horse is dead and still he says to B, I'll sell you my horse. This is fraud. Generally, in case of fraud, it is voidable. But along with fraud, it is also impossible to perform. So because it is impossible to perform, the contract is void. But I can claim the damages, right? But I can claim the damages. I hope it's clear to all of you. Can we move forward? Yes. Now, to the next one, supervening impossibility. When the contract was made, it was valid, but before the contract could be performed, changes take place, making performance impossible, making the contract void. Post-contractual impossibility or subsequent impossibility. We have, except these 5 cases, please remember, no other case is supervening impossibility. If after the contract is made, but before the contract is performed, the subject matter is destroyed. I have made the contract for a specific state of things, and that state of things does not exist. Personal skill and confidence, and the promiser is swaha. I made a contract with a person of another country, but before the contract could be performed, there is a war. If there is a war and I make a contract, that's illegal, void ab initio. Here, after the contract is made, there is a war. I agree to sell this pen to you, you agree to purchase. But before I sell this pen, there is a new law where selling this pen is not allowed. Change in law. In case of supervening impossibility, I cannot claim damages because it's not my fault. But I have a right to get back the money I have paid. The last one, breach, that is non-fulfillment of the terms of the contract. Breach can be before the due date or it can be directly on the due date. Before the due date, I come to know one party will not perform. The other party will not perform. I can either cancel or wait. If I cancel on that day, I can claim damages. If I wait and on the due date the other party performs, I should accept. If on the due date the other party does not perform its actual breach, I can cancel the contract and claim the damages. Marathon, 1 day, it's on the due date. But classes went over a period of time. So the due date started from the day class started and it ended on the last day of the class. So that is not, it is a period of performance. So in that case, if in the middle we breach the contract, it's known as actual only, but it is during the course of performance. With this, we are done with this unit. Again, before I go forward, anyone has any doubts, you ask me and then we will go forward. Yeah, Romita, where are you girls? Supervening impossibility means when the contract was made, it was valid, but before the contract performance could be done, changes take place. Changes not in our control, but these changes make the performance of the contract impossible and so make the contract void. That means after the contract is made, it becomes impossible to. Yeah, I told you yesterday, guys, I'll send this PDF. This PDF and yesterday's whatever PDF I used, today I'll upload it on my channel. Okay? Anything else? Can we go forward? Now, moving forward, the next one is remedies for breach. Obviously, if there is a breach, I will have some remedies. Restitution is refund of the money. That is it. That is the meaning. Refund of the money. Remedies for breach. Lohit, I hope you understand. Now, if the contract is breached, do you think the aggrieved party will have some rights against the other party? That is what we will discuss in remedies for breach. When I talk about remedies, we can actually classify the remedies under two heads. Monetary rights, that is damages, and other rights. Monetary rights, which we call damages, obviously the name is only telling it is something in the form of money. Correct? It is something in the form of money. So the whole concept of what damage can or cannot be claimed was laid down in the case of one thing. Let's see how many of you remember the minors case. Let's see how many of you can write down the name of the case. Minors case, where it was held an agreement with the minor is void. Chalo, let's see. Chalo, all of you put down the names of the case. Do you remember? What was the name? Don't look into the book. Don't look into the book. Don't look into the book. The minor's case, where it was held, agreement with the minor is void. Come on, don't tell me none of you remember. Oh my God, seriously? Mohini Bibi versus Dharmodas Ghosh. Chalo, the rules of damages laid down in the case of Hadley versus Baxendale. Today you guys are not in the mood to respond. So Chalo. First, any damage which arose naturally in the ordinary course of the business can be claimed as a matter of right. Second was special damage can be claimed only if there is a notice of the special loss. Remote damages. What is remote damages? Indirect damages can never be claimed, and any damage under a quasi contract can be claimed. So these were the rules which were laid down. So on this, ordinary damage, can you claim it? Yes. Doesn't matter if the contract says or the contract does not say. If there is a damage, I can claim it. The fact that I've made a contract and the fact that this contract was breached gives me a right to claim these damages. These damages are market price less contract price or contract price less market price, as the case may be. I don't have to give a notice to claim it. The fact that contract was breached automatically gives me a right to claim these damages. Special damages is not my right. So I have a right to claim the special damage. It's enough. I can claim it only if I give a notice of the same. Nominal damage, sometimes it may happen that actually the parties have not suffered any damage on account of breach. So if you have not suffered any damage, you will not get any damage, because the concept of damages is to make good the loss. The concept of damages is not to make profit. So you cannot claim these damages. Right? So you cannot claim these damages. So nominal damages cannot be claimed. So normally when there is no loss, damages cannot be claimed. But just to respect the Indian Contract Act, because Indian Contract Act says if there is a breach, damages has to be given. We give a damage which is as less as 1 rupee. This is known as nominal damage. Vindictive or exemplary damages, they are basically punitive in nature. Punitive means punishable in nature. And because they are punitive in nature, they are not awarded in all the cases, only in 2 cases. What are the 2 cases? Breach of contract of marriage or wrongful dishonor of a customer's check. What is wrongful dishonor of a customer's check? Tell me. What do you mean by wrongful dishonor of a customer's check? Tell me. It's wrongful dishonor of a customer's check. Yesterday you guys had more Josh. Today everything is okay. Now I won't ask a question, I'll just do the chapters. You people sit and do it. Okay? Wrongful dishonor of a customer's check means the person has balance in his account but still his check is dishonored. Now when we talk about penalty and liquidated damage, these are damages which are already mentioned in the contract. Beforehand only I mentioned these damages. Tomorrow if there is a breach, this is the damage you can claim. Now it is not a special damage, it is ordinary damage only, but we mention that this amount can be claimed. So that amount becomes the ceiling limit. You cannot claim anything more than that. Now penalty means a amount which is very, very, very high. That means what? I mention a very high amount as damage. Oh my god, it looks like time. I mention a very high amount as damage which is nowhere near to the actual damage suffered. On the other hand, liquidated damage is an estimation of the probable damage. Whatever you write, you will only get what you suffer, nothing more. You will only get what you suffer, nothing more. Now, these other rights are available apart from monetary rights. Is the class on? Can you actually follow the class? Can you see the class? Can you hear me? Now see the replies, but when I asked the question, no replies, huh? Now, other rights are available apart from monetary right. That means you can claim these other rights. Other than that, you can also claim the damages. The first one, sue for rescission. One party is ready to perform, but the other refuses to accept. So one party will sue the other party to cancel the contract. One party will sue the other party to cancel the contract. Obviously, beyond that, you can also claim the damages. Quantum period, if a part of the contract is performed, then payment shall be made for the part performed. Here we have a few things. If a contract is if the contract is separable and a part is done, we have to pay. If the contract is not separable and a part is done, I don't have to pay. But if I accept that part, I must pay. If the person has done the work not intending to do it gratuitously, I must pay him. If the contract, a part is performed and then the contract becomes void, whatever part has been performed, I have to pay for that. Then the next one is if a contract is, if the contract is, if the person has done the work but he has not done the work as is required of him, then in that case, whatever work he has done, we have to pay him reasonably for that. So these are the 5 things that we need to remember for quantum period. The next one, specific performance. When I say specific performance, it basically means I am suing the other party to perform the contract. I repeat again, specific performance, what it means is I'm basically suing the other party that you have to perform the contract. When we talk about specific performance, in 2 cases you can sue for specific performance if the goods have no substitute and the damages are not an adequate relief. Then in this case, if the goods are a certain goods, you can sue for specific performance. This is actually given under the Sale of Goods Act. Okay? You can sue for specific performance. Goods have no substitute, antique goods. Damages are not an adequate relief. That means damages not getting the, getting the damages will not be sufficient for non-performance. So there I will sue the other party to perform. Now if it's a minor, can I sue the minor to perform? No. So that is why specific performance does not apply on a minor. Last one is injunction. Injunction always relates to a negative act. When in a contract, there is a negative term and one of the parties breaches the negative term. For example, we have a contract that till the time you're working for me, you cannot work anywhere else in this city. You take up another job. Can I stop you from doing that job? Yes. Injunction, negative act, you breach it I can sue you to stop you from doing that. With this, we are done with this chapter. And now we are done with the second part of Indian Contract Act, that is performance. And we will start with special contracts beyond this point. I'm just taking 5 minutes before we start. Okay? Okay, so moving forward to our last bit. Though I cannot deny this, that this last bit is not a small bit. Can we move forward? Yes. So, contingent contract. These special contracts are important from exam point of view also. And we'll try to do it a little bit in details. I'm hoping you will actually reply a few times here and there. Okay. So we have 7 special types of contracts, starting with contingent. The word contingent only means what? May or may not. So what is a contract? Contingent contract, an agreement to do or not to do something. To do or not to do something on the happening or non-happening of a future uncertain event. Right? To do or not to do something on the happening or non-happening of a future uncertain event. So, can I say, I will give you the goods if I'm able to get them. This is what contingent. Remember contingent goods we had done. If you remember, we had done contingent goods. This is the same thing, right? This is the same thing. So if I look at this, what are the characteristics of a contingent contract? First and foremost, it is always dependent on a future uncertain event. Right? It is always dependent on a future uncertain event. Second, the event must be a collateral event. That means it should not be a part of a reciprocal promise. I will give you money when you do this. So it's the event on which the contract is dependent is coming from you. And when the event is coming from the other party, it is not collateral. Collateral, a contingent contract is never dependent on the will of the promise. It can depend on a future uncertain event or anything, but never on the will of the promise. Now, when I say contingent contract, it is dependent on the happening of an event. I will sell you the land if I get it from C. Now, if I get it from C, should I sell? Yes. If I don't get it from C, should I sell? No. So, it is valid when the event happens, becomes void when the event does not happen. But something is wrong. Guys, is there any problem, guys? Now, okay. It says to be, I will give you the goods. I tell you, I will sell you the land if I get it from C. If I get it from C within 2 months. If I get it within 2 months, I have to sell. If I don't, I won't sell. Now, can it depend on the non-happening of an event? Yes, I will give you money if the ship does not come to the port. The ship sinks. If the ship sinks, it will not come to the port. Valid. If the ship comes to the port, so if it is dependent on the non-happening of an event, it is valid. If the event does not happen, becomes void if the event happens. Can it depend on a third party? Yes. In that case, if the third party acts accordingly, valid, otherwise void. A says to B, I will give you rupees 1 lakh if I am able to marry C. Now the contract is completely dependent on C. If C marries D, contract is void. If C marries A, contract is valid. If it is dependent on impossible event, A says to B, I will give you half the treasures I discover by magic. Now, this is not some Jumanji magic, abracadabra, Wingardium Leviosa. Impossible event. It's void ab initio. Is it clear to all of you? Contingent contract clear to all of you? What is a quasi contract? there is no contract between the parties, but a contract is created by law, right? There is no contract between the parties, but a contract is created by law. So if I say features, what's wrong with my laptop? If I say features, what are the features of quasi contract? First, an obligation is created. How? Without contract, right? Obligation is created without contract. Second, this is basically a right for money or generally a liquidated sum of money. So basically this right is only for money or money is worth. Third, this is a right against a person and not the whole. So there are 5 types of quasi contract. First, goods delivered by mistake or under coercion. If I have to deliver goods to you, but by mistake I deliver it to them, can I recover the goods from them? Yes. If they have used the goods, I can recover the money. So goods delivered by mistake or under coercion. If a person supplies necessaries to a minor or to a lunatic's family, or to a lunatic, as between the minor and the supplier or the lunatic and the supplier. Family means, always remember, dependent family. So as between the lunatic and the minor supplier, or as between the minor and the supplier, there is no contract, but there is a quasi contract according to which I should get back the money I have. If I have made a payment on behalf of a third person, I have made the payment or to protect my interest, very importantly to protect my interest. The other person was supposed to pay, but I paid. Can I recover the money from that person? Yes. Now listen carefully, work done non-gratuitously. Listen very carefully. This I am going to link it with consideration must move by the desire of the promisor, and I am hoping you guys will answer. Your car is not working. I get the car repaired without you telling me. Are you liable to pay me? Why not liable? Because consideration. Yes, exactly. Consideration must move at the desire of the promisor, not liable. But you see me getting the car repaired and you don't stop me. You see me getting the car repaired and you don't stop me. Can I now recover the money from you? That is work done non-gratuitously. That is what? Work done non-gratuitously. One person does the work for another without being asked by him, and the other person enjoys the benefit. He must pay for it. Finder of the goods, go to bailment. There it is in details. With this, we are done with quasi contract. Any doubts? Otherwise, I'll move to indemnity. Clear? We'll go forward. Okay, the next one, contract of indemnity. Guys, why is it that yesterday you were replying so much? You had so many things to say. Today you're not replying, not asking. Indian Contract Act was never so easy, I thought. Tell me on a very serious note, huh? Doubts. Okay, contract of indemnity. Indemnity means what? To make good the loss. Okay, one more thing. Just let me know. You still want me to do the detailed revision like we did for the other chapters for Indian Contract Act? Do let me know that. Okay. So, contract of indemnity. What is contract of indemnity? Indemnity means to make good the loss. To make good the loss. So, party 1 is making a promise to party 2. What promise? That I will make good the loss suffered by you because of my fault or anyone else's fault. Okay? Party 1 is saying to party 2 that look, party 2, if you suffer any damage or loss because of me or because of anyone else, I will make good the loss suffered. This is indemnity. The person who makes the promise is indemnifier, and the person to whom the promise is made is the indemnified or the indemnity holder. Now, what are the rights of this indemnified or indemnity holder? Let us say I found some goods lying on the road, I picked it up. You come and say, ma'am, it is my goods. I'm in a dilemma, should I hand it over to you or not? You're like, no, ma'am, it is mine, don't worry. Then you say, okay, ma'am, I'm giving you a promise. If tomorrow someone else claims these goods, and because of that, if you suffer any damage, I will compensate you for the damage. Okay. Now, one day someone comes and says, ma'am, you found my goods. I found on CCTV. Which goods? Ma'am, my goods, they were lying on this road, you picked it up. I'm like, shit, someone else took the goods. No, ma'am, the goods were mine. Now, the person proves they are his. He takes me to the court. So, when he files a case against me, I also have to hire a lawyer and all that. So, that cost. I lost the case, so I have to pay him damages. That damages. Can I recover it from you? Can I recover it from you? Yes. So this person comes and says, ma'am, it was my goods. How could you give it to someone else? I say, that person proved it. Says, no, how could he prove it's mine? We have a fight. Then he's like, I'm going to go to the court against you. I'm like, oh, please, most welcome. He's like, you serious? I am very serious. Not be serious. If I go to the court, you don't know what will happen. What will happen? If I go to the court, you will lose the case. Yeah, whatever. Go. You go to the court, my great grandson will give the money to your grandson. So I tell him outside the court, you take damages from me, I'll give you the damages. So we settle outside the court. So if I pay money in this compromise, can you recover this money paid in compromise? Yes, can recover the money paid in compromise. Here, can we go to guarantee? Yes. Guys, if you have any doubts, you please ask me till then. Can we go forward? Now, contract of guarantee. What is guarantee? What is guarantee? Guarantee is an assurance to the creditor that if your debtor does not pay, I will pay your debt. Or if the other party does not perform, I will perform on his behalf. Right? I repeat again, what is a contract of guarantee? A contract of guarantee is a contract whereby one party promises to perform for another or to pay on behalf of another in case he fails to do so. The person who makes the promise is called the surety. The person to whom the promise is made is the creditor. And the person on whose behalf the promise is made is the principal debtor. Now, please understand how much will the surety be liable for? How much will the surety be liable for? I am liable because the principal debtor is liable, right? I can never be liable more than what he is liable for. I can never be liable for. So it's coextensive. So if he is liable for 5 lakh, my maximum liability can be 5 lakh. Can it be less? Yes, but never more. Never more. When will the liability of the surety arise? The moment the principal debtor makes a default, the surety is liable. The moment the principal debtor makes a default, the surety is liable. And let's say there is a defect in the papers because of which the principal debtor is released from liability. Guys, please understand, I am liable because principal debtor is liable. If he is not liable, how can I be liable? I hope it's clear to all of you. Now, what are the types of guarantees we have? Specific, continuing. Specific means for a single transaction. Continuing means it moves over a series of transactions. When I say continuing, it moves over a series of transactions. But it can be time bound or amount bound. Whatever goods you sell him on credit, if he does not pay, I will pay up to 5 lakh rupees. It is still continuing. Whatever goods you sell him on credit for the next 6 months, if he does not pay, I will pay. This is also continuing. So it can be time bound or it can be money bound. I hope it's clear to all of you. Yes. Now, what are the rights of the surety? Please understand, this surety will have the rights against the principal debtor, the rights against the creditor, and the rights against the co-sureties. What is the rights against the principal debtor? Rights of subrogation. What is this rights of subrogation? The moment he pays off the creditor is out of the picture, but he steps into the shoes of the creditor. Guys, he doesn't tell the creditor, hey, open your shoes, I will wear it. No. He becomes the creditor for the principal debtor. That means what? All rights of creditor now passes to the surety. This means what? All rights of the creditor now passes to the surety. Correct? The next one, rights of indemnification. If on the due date the surety is paying off the creditor is out of the picture, but can the surety recover the money that he has paid from the principal debtor? You will tell me yes or no. Can he recover? Can he recover, guys? Tell me. Exactly, he can recover, and this is known as what? Indemnification. This is known as what? Indemnification. Now, against the creditor, what he has rights. If the creditor has taken any security, like surety has given the guarantee, apart from that, he took some jewelry from the debtor. So, he has taken a security. So, on the due date, when the surety pays off the creditor, all this rights goes to the surety. So if the creditor has taken any security from the principal debtor, this security will pass to the surety now, even if he is not aware of it. So let's say loan was 15 lakh rupees, he took a jewelry of 12 lakh. On the due date, when the surety pays off that 15 lakh, he can recover that 12 lakh jewelry even if he is not aware. Now, what the creditor did, he returned the jewelry to the principal debtor. I have to get it. You return it to the debtor, I am discharged to the value of the security. Is it clear to all of you? Yes? Against the co-sureties, he has a right to recover their share. If they are bound by equal amount, he can recover equal amount from them. If they are bound by different amounts, he can recover their respective share from them. Right? With this, we are done with the rights of the surety. I hope it's clear. After we are done with discharge, then I'll ask you if you have any doubts. Discharge of the surety. Before I do this, can a specific guarantee be revoked? No, because the guarantee is already given, and the fate of your guarantee, the person has incurred liability, so it cannot be revoked. But can a continuing guarantee be revoked? Yes, it can be revoked with respect to future transaction. It can be revoked with respect to future transactions. I hope it is clear to all of you. Yes. Now, discharge of the surety by notice. If it is a specific guarantee, cannot be revoked. If it is a continuing guarantee, can be revoked with respect to future transactions. Death. In case of death, the legal heirs are liable for specific guarantee, but not personally to the extent of assets inherited. In case of continuing guarantee, for future transaction, the guarantee is revoked. For transactions already made, the legal heirs are liable. The legal heirs are never personally liable. They are liable only to the extent of assets inherited. Innovation in place of the old surety, a new surety steps in. So the old surety is discharged. Any variation in the terms of the contract discharges the surety from the date of variation. That means the principal debtor and the creditor make any variation. They change the time of repayment, the interest rate. If it's a salary, they change the salary without informing the surety. Then from the date of variation, the surety is discharged. Then why liable? Because the principal debtor is liable. If the creditor releases the principal debtor, how will I be liable? You ask someone to build a house for you, and I give a guarantee for that if he does not construct, I will construct. You tell him I will supply the material. You don't supply him the material, how will he build the house? So now you say, ma'am, see, he never built the house. Your fault or his fault? Your fault. So can I be held liable to perform? No. Because when you did not supply him material, you discharged him from liability. So when that person is discharged from liability, obviously I am also not liable. The next one, when the creditor makes a composition with the principal debtor, what is composition? Instead of 10 lakhs, I will pay 8 lakhs. See, when I make a change in the amount, that's composition. But subordinate points like time of payment or rather not even time, I would say rather I'm changing the rate of interest, changing the installments of payment, all that. That is known as variation. But if I change the amount payable, that's composition. Or the creditor promises to extend the time of repayment, or the creditor agrees not to sue the principal debtor and the surety is not informed. What will happen? The surety is completely discharged. In variation, I am discharged from the time the variation happens, but here I am completely discharged. But let's say the creditor agrees with a third party that I will not sue the debtor. Okay, this is the question for all of you. The creditor agrees with the third party that I will not sue the principal debtor. Is the surety discharged? Is the surety discharged? See, here it's very clearly given. There is a contract between the creditor and the principal debtor. If he agreed with the principal debtor not to sue, then he would have been discharged. But here, did he agree with the principal debtor? No, with the third party. The principal debtor is not discharged. I hope it's clear. When the creditor impairs the right of the surety, impairs means hampers. Like he took a security of 12 lakh and that security was lost, or he returned the security back to the principal debtor. You took away my right. I am discharged to the extent of the value of the security. Or where the guarantee is obtained by concealment of material facts, that is, without concealing the material fact, the creditor gets the guarantee. So the surety is not liable. In this, there is one more thing. It is obtained by fraud or misrepresentation. In that case also, the surety is not liable. So we are done with guarantee. Anyone has any doubt, you will ask me that and then we will continue. understanding. Too smart people you are, na? So moving on to the next one, bailment. Oh my God, we're about to finish the chapter. I can't. Um, Actually, yeah, if someone dies, I promise to pay you if someone dies. It is an event, but it is very sure to happen. And contingent is something which may or may not happen. So I cannot call it contingent because contingent may the event may or may not happen, whereas dying is something very sure that person will die. I hope you got it right. Can we go forward? Contract of bailment. Bail, jail, no connection. So basically, what I am doing is one party is giving the possession of the goods to another party. Now, if I'm giving you the possession of the goods, if it's a promissory note, it's a valid promissory note. It's conditional, but it's something which is sure to happen. So it's not considered as conditional. Clear, Ben? So the contract of bailment, in what is happening in contract of bailment, I am giving you the possession of my goods. I am giving you the possession of my goods. Why am I giving you the possession? Am I giving you ownership? No. I am not giving you ownership. I'm only giving you the possession of my goods. Why am I giving you the possession of my goods? For a specific purpose. For a specific purpose. And once the purpose is attained, can the other party keep the goods? No. The other party must either return the goods back or pay the price of the, or I'm so sorry, or dispose of the goods. Let's just give me 1 minute. Oh, अच्छा, 1 minute. can you hear me? No, it's not a break. I had to step out for a minute from the class. Can you hear me? Am I audible? Can you hear me, guys? Okay. I'm sorry, I had to step out for some work. So, party one. So, am I transferring the ownership? No, no, no. I'm just giving the possession of the goods to another person, and I'm giving it for a purpose. And once the purpose is achieved, the other person cannot keep the goods. He must return the goods back to me, or he must dispose of the goods. So, this is what? This is contract of bailment. The person who gives the goods is the bailer, and the person to whom the goods are given is the bailee. Now, can we say this bailer will have some duties? Yes. But before that, what are the features of bailment? First of all, there has to be some goods. So, bailment is always, remember, only for movable goods. For immovable property, I can never have bailment. Bailment can never be for immovable property. Then second, there must be delivery of the goods. Now, the delivery can be real, that is actual, symbolic, constructive, anything, but delivery has to be there. Then third, when I say delivery, it must be a transfer of possession and not just custody. What is the difference between possession and custody? Possession means I can access the goods at any time, right? What is possession? Possession means I have a right to access the goods at any time. And then there must be a return of the goods. When I say return of goods, it is the same goods which are returned or the same goods in the altered form which is returned. But when I talk about money, please remember money is not goods. So if I give you money, that's not bailment. Now, can we say there are two types of bailment? Bailment may be gratuitous or non-gratuitous. When I say gratuitous, okay, when I say gratuitous means it is done not for money. A non-gratuitous means it is done for money. When it is gratuitous bailment, that means it's not for money. That means both the parties cannot be benefited. So it can be either for the benefit of the bailer or it can be for the benefit of the bailee, never for the benefit of both the parties. But when it is a non-gratuitous bailment, obviously both the parties are benefited, right? Obviously both the parties are benefited. Let's talk about duties. What are the duties of the bailer? What are the duties of the bailee? First, duties of the bailer. Can I say duties of bailer is nothing but rights of bailee? Am I right if I say this? And unless you say yes, I'm not moving forward. Unless you say yes, okay. So, what are the duties of the bailer? First of all, to disclose fault in the goods. Now, remember, if it is the gratuitous bailment, I am liable only for the known faults. ISPE case studies, you can get a lot of them. So, please, guys, remember all of these very carefully. If it is a gratuitous bailment, I am only liable for the known faults, but if it is a non-gratuitous bailment, I am liable for both known and unknown faults. Then repay necessary expenses. When it comes to expenses, no, ordinary expenses are borne by the bailee, extraordinary expenses are borne by the bailer. But if the contract is for the benefit of the bailer, both ordinary and extraordinary expenses are borne by the bailer. Okay? Then give back loss suffered due to defective title. If the title of the bailer is defective, let's say stolen goods, you gave me stolen goods to keep. Now, because of that, someone comes and claims the goods from me. I suffer damage. Can I claim those damages from you? Yes. Then, bailment is over. I return the goods back to you. You don't want to keep it. No, ma'am, it is okay. You keep. No, you keep. No, please take your goods. No, ma'am, it is okay. You keep. No, you keep. Can you do that? No. It is your duty to take back your goods once the bailment is over. And see, now what happens is, if it is a gratuitous bailment, okay, or if it is a gratuitous bailment, it can be terminated at any time. But if it is a non-gratuitous bailment, only on the then you cannot terminate it just like that. It will be terminated only as per the time or purpose. Gratuitous bailment can be terminated even before time. So I gave you the goods for 1 month, but after 1 day I say give my goods back. So whatever you damage you suffer because of that, can you claim that from me? Yes, you can claim that from me. Is it clear to all of you? Yes. Now, what are the duties of the bailee? Can I say the duties of the bailee is nothing but rights of bailer? Yes. Duties of bailee is nothing but rights of the bailer. So what are the rights? First, to take reasonable care of the goods. What do I mean by reasonable care? That care that a prudent man would take. And if I take reasonable care and if something happens to the goods, I am not liable. But you know what? Even if I have taken reasonable care, I may be liable if I fail to follow the instructions of the bailer, or if I fail to return the goods within the time. Now, not to take unauthorized. Now, when the bailer has given the goods to me, he might have given it to me for a specific purpose. I should only use it for that purpose. I should not make unauthorized use of the goods. I should not mix the goods with my own goods. Right? I should not mix. If I mix it with both the consent of both the parties, then it will proportionately belong to each of us. But if I mix it without the consent, if it is separable, I should get it separated. Cost of separation will be borne by me because it's my fault. If it is not separable, I have to pay the reasonable price of the goods. Then not to set up any adverse title over the goods. Like for example, you gave me your goods. I wanted loan, gave your goods as a security for the loan. I cannot do that. Not return any increase to the goods and return the goods. If any increase happens to the goods, like for example, I gave you shares, the company gave bonus shares on that. I gave you my cow produced calf, right? So I have to return the increase to the goods and obviously to return the goods once the bailment is over. Now, apart from these rights which we discussed above, the bailer and bailee will have certain other rights also. So what are the other rights of bailer? If we have already discussed this, if due to unauthorized use of the goods by the bailee, the bailer suffers any loss, he can recover that loss from the bailee. In case of a gratuitous bailment, he can cancel the contract. If due to the third party any loss happens to the goods, even though the goods are in the possession of the bailee, goods belongs to the bailer, bailer can sue the third party for the loss. This will be rights of bailee and not bailer. What are the rights of the bailee? Two or more persons are the owner of the goods. I return the goods back to any one of them. Guys, tell me, if I return the goods back to any one of them, is it a valid return of goods? To any one of them, is it a valid return of goods? Yes. If he has delivered to one of the joint bailers, it's a valid. A gave the goods to B on bailment, but A says to B, return the goods to C. He returns the goods to C. Is his obligation to return the goods over? He returns the goods to C. Is his obligation to return the goods over? Is his obligation to return the goods over? Yes, over. It is over. Okay. Then A gave the goods to B. C, I don't know who is C, is saying and coming and saying to B, hey, give my goods, give my goods. B is like, A gave me, no, my goods, my goods. Can B go to the court against C? Yes. Right to apply to the court to stop delivery. If any person other than the bailer demands the goods back from the bailee, he can go to the court to stop that person from getting the goods, right? Then, if due to the third party the goods have anything happens to the goods, bailer is the owner. He can claim compensation, but even the bailee, because he has the possession, he can claim the compensation. So this point 4 and this point 4 is basically the same right. Bailer is the owner. He can claim compensation, but even though bailee is not the owner, but since he has the goods, he can even claim compensation. I hope it is clear to all of you. The last one is rights of lien. What is this right of lien? There are two types of lien, particular lien, general lien. I have rendered some services. You have to pay me for my services. You don't pay me for my services. Can I stop the goods? Yes, this is particular lien. What is general lien? This is not right for everyone. It is only the banks, the CAs who can exercise these lien, these professionals. It is a lien on the general balance of the account. So let's say you have two FDs with the bank, and against this FD you have taken a loan. You want to encash this FD. Bank says no, first pay the loan, then encash. You are like, it's against this FD. Bank is like, no. Can the bank stop you from encashing this FD? Yes. The bank can stop you from encashing the other FD also. Right? Okay, I'll give. Then the next one, responsibility of the finder of the goods. Can I say there is a quasi contract between the owner and finder? Yes. That means contract of bailment can be express or implied, and finder of the goods is implied contract of bailment. He betrays the owner and returns the goods back to him. Now, what are the rights of the finder? Can he exercise a lien over the goods? Yes. For the expenses that he has incurred. For the expenses that he has incurred, he cannot sue the other person because it's your choice you incurred. But I can exercise a lien over the goods. If you have announced a reward, can I also sue for that reward? Yes, I have a right to recover that reward. You have my phone, you found my phone. You're like, this is your phone. I'm like, yeah, this is my phone. Give me money, I give you phone. Can you do that? No. But if I have announced the reward, can you ask for the money? Yes. If the goods are perishable or the owner is not found, or the owner is found and he refuses to pay the charges that I've incurred. What charges? Like searching for the owner, keeping the goods, taking care of the goods. I might have incurred some charges. Whatever charges I've incurred, you must pay me. If you don't pay me and the charges are 2/3 or more of the value of the goods, I can also sell the goods. Let us say the value of the goods is 1,000, I incurred 100. You have to tell me, can I sell the goods? No. But can I exercise the lien over the goods? Yes. So can I exercise the lien? Yes. Sell the goods? No. But let us say I spent 800, then can I sell the goods? Yes. Now, what are the obligations? He must not mix the goods with his own goods. He must trace the owner and return the goods back to him. He must not use the goods for his personal use, and he must take care of the goods, right? And with this, the end of bailment. When does bailment come to an end? If it is for a purpose, the purpose is over, time is over, subject matter is over, parties are over. Gratuitous bailment, anytime it can be terminated, and the bailee makes unauthorized use of the goods. You give your book to your friend and you tell him don't mark it from pen. Pen to chodo, he's using different colored highlighters to mark it. One line is green, one is pink, one is red. You are, oh my god, what is this? You snatch your book. Can you do that? Yes, because he made unauthorized use of the goods. And with this, bailment is over. You want 10 minutes ka break? You want? Yes. Hello guys. With this, we are bailment is over. 10 minutes, 15 minutes. Go. For 15 minutes you go. It's 12:26. I'll see you at 12:40. Okay? I'll see you at 12:40. Bye bye guys. मैं तो क्या ढूंढूंगा मैं तो तुम बोल रही you don't come you just send book and go and send it here हाँ मतलब we have book one in over from here हाँ makes no sense or any but we have to talk to them we want to pay okay are you back guys hello hello yeah I can see you are back with the bang so this is going to be the last leg of the marathon right so this will be the last leg of the marathon Oof. Sure Preetam I'll do it not this week coming week I'll do it okay coming week we'll do it what is pledge I want everyone's attention here now what is pledge basically pledge is bailment of goods no problem I'll upload it on my Instagram when and how it will be done okay what do I mean by pledge pledge is bailment of goods that means I'm giving my goods to you as a security security for what for the payment of a debt or the performance of a contract I am giving you my goods as a security for payment of a debt or for the performance of the contract the person who gives the goods is the owner and the person to whom the goods are given is the pawnee it's a payment of goods so owner is the bailer pawnee is the payee don't forget that okay what are the duties of the pawnee okay here there is a little bit of a problem ulta ho gaya ठीक है so basically this will be the duties of pawnee and this is the duties of owner okay that's it duties I'm not going because we've already done this what do you say we've already done all of this concept when you were doing bailment so I'm not going into this there are rights that I want to discuss rights of retainer can I exercise a lien over the goods? Yes. Bailment may I can only exercise lien for what? I can exercise a lien over the goods. For what can I exercise the lien? In case of bailment, for the charges of my service. Here, lien can be exercised for the principal amount, for the interest amount, and for ordinary expenses also. You cannot exercise a lien for extraordinary expense. Extraordinary expense, no lien. You can recover that expense. You can sue the other party for that expense, but you cannot exercise a lien. But for principal, interest, and ordinary expense, you can exercise a lien. If let's say I have given you my goods as a security and I subsequently give you more loans, Can you exercise a retainer for the subsequent loans also? Yes. Can I exercise a retainer for subsequent loans? Matlab kya? You have given me your goods as a security and I gave you a loan. Further, I give you more loans. Can I keep that goods as a security for the further loans also? Yes, I can do it. Good, good. Happy to see you guys back. Rights. When the pawnee makes a default, I can also what? I can also, the pawnee can also sell the goods. That means if you fail to pay, I can also sell the goods. And when it comes to the rights of the pawnee, once the pawnee has paid the money, he can get the goods back. If let's say he doesn't pay the money on the due date but pays on a later date, but the goods are still with the pawnee, he can get the goods back. Is it clear? Pledge by non-owners will not do. We've already done this in demo that for non-habit, so I don't want to do all this again. Okay? Can we go forward? Contract of agency. Contract of agency. What is contract of agency? Contract of agency is a contract whereby one person acts on behalf of another, that is, represents another person or acts on behalf of another. The person for whom the act is done is the principal, the person who does the act is the agent. For the acts of the agent, who is liable? Principal is liable. Now, when we talk about agency, always remember, even a minor, can a minor be an agent? This person is the agent. Can a minor be an agent? Yes. But can a minor be a principal? No. Why? Because who will be liable? And if he is the principal, my agent is personally liable. So minor can be an agent but not a principal. Now, let's talk about agency. How is agency created? It can be expressed or implied. What is express? Express is by words, oral or written. So when I expressly tell you, you act as my agent, it's express agency. Never important from exam. What is important is implied. What is implied agency? By estoppel, by ratification, wife as an agent, agency in necessity, agency by operation of law. By estoppel, in front of others, I tell them that you are my agent. You become my agent by estoppel. Now, if you go and make a contract with the third party, am I liable? Yes, I am also liable. Agency by holding out, in the book you will not see this, but I'll just tell you. Earlier, there was a relation of principal and agent between us. Earlier, there was a relation of principal and agent between us, but as of today, you are no longer my agent. But the world knows you are my agent, but we did not give a public notice. So again, if you make a contract in my name, the world thinks you are my agent. So this is agency by holding out. Agency by necessity. In an emergency, a person acts on my behalf to protect my interest or to protect me from loss. This is agency by necessity. But for agency by necessity, it's very important that he must have acted as a man of ordinary prudence. Second, there was a real necessity for which he did the work. Third, he was not in a position to communicate with me. This is what agency by necessity. The next one, agency by operation of law. The best example for this is partnership. By the effect of law, agency is created. Wife as an agent. Is the wife considered as an agent of the husband? Yes. She can use the credit of her husband, but she is the agent only for necessaries. Now, what is necessaries? Depends on the status of the life. For one person, one thing may be necessaries. For another, another thing may be necessaries. So, depends on the status of the life. Now, if they are living separately, no fault of wife, she can use the credit of her husband. If they are living separately, fault of wife, she cannot use the credit of her husband. If they are living separately and he pays her maintenance expenses, cannot use the credit of the husband. That means in these cases, she is not the agent of the husband. Agency by ratification. Two things. I am not your agent, but I act as your agent. This is called pretended agent. Or you have given me some authority, I do the act outside my authority. So either I am an agent, but I do the work outside my authority. Second, I am not your agent, but I make a contract in your name. This is what agency by ratification. Now, if I am an agent, but I do the act outside the authority, for the work which is within authority, you are liable. But for the act which is outside the authority, you are not liable. Correct? You are not liable. I am not your agent, but I make a contract in your name. You can refuse. If you refuse, fine. If you accept, you are liable. Pretended agent. But for ratification, a few things have to be there. Ratification must be of the whole contract. Ratification must be within the reasonable time. Ratification must be communicated. Ratification must be of the whole act, correct? Then ratification must be on the knowledge of all the material facts. That means before ratification, I should know all the conditions are fulfilled. Then ratification is it clear to all of you? Now, termination of agency will come to it at the end. Let's do the rest of it later. How much agent can do? What all agent can do? In the normal course of the business, to do the normal acts, can you do all the lawful acts to conduct the business of the principal? Yes. In an emergency, he can do any act that a man of ordinary prudence would do, but it should be done to protect the principal from loss. He can do any act which a man of ordinary prudence would do, provided there is the real necessity and he was not in a position to communicate. This all we have already done, where agency by necessity. Right? Now, duties of these, from these sections, they ask a lot of questions. So, duties of the agent. We are talking about duties of the agent. He must follow the instructions or the customs. If he fails to follow and the principal suffers any damage, he must indemnify the loss to the principal. Right? He must use his reasonable care and skill while doing the business. For example, a person is known that he is not a good person, he never pays his money. Still you go and sell him the goods on credit. You should have checked, no? So, he must do the work with reasonable care and skill. If he neglects and the principal suffers any loss, he is liable for that loss. Whenever the principal asks him for the accounts, he must render proper accounts to the principal. In case he does not know what to do, when he is unable to decide how to do the work, he must communicate with the principal and try to figure out how the work should be done. Right? Is it clear? He must not deal in his own account. He cannot make a contract in his own name. He cannot make a contract in his own name. And if he does, the principal can cancel the contract. Or if he is making a contract in his own name and because of that he suffers any benefits, the principal can claim those benefits from the agent. He must not make any secret profits. What is secret profits? If he earns anything over and above his remuneration. If he earns anything over and above his remuneration, he cannot. And if he does, must give it to the principal. Let's say if he would have given it to the principal, he wouldn't have needed it. Duty not to delegate means what? Not to appoint a sub-agent. And guys, if he appoints a sub-agent, he will be liable to the third party for any loss. Okay? Duty to pay sums received for the principal. If he has received any money on behalf of the principal, he must give that money back to the principal. Right? Last one. If while doing the business, obviously while doing the business, you will come to know about confidential informations of the principal. You cannot leak those informations of the principal to anyone else. With this, we are done with the duties. Guys, you have anything that you want to ask me, please ask me before we move forward. Please ask me any doubts you have before we move forward. No doubts? Okay. Rights of the agent. So this was duties. Duties means obligation. Rights means what I will get, right? Rights means what I will get. Right to retain out sums received on principal's account. That means if he has received any money on behalf of the principal, from that money he can deduct the following expenses. If he has paid some advance to the principal, like the principal gave him the goods, he paid some advance money to the principal. Can he deduct that? Yes. Second, if he had incurred expenses in the business, I might have to incur expenses like packing of the goods, I have to do it, was my obligation to do it, you will pay the expense, or I have to do some advertisement. So whatever expenses I have incurred, I can claim that expense also. Third, whatever remuneration is payable to the agent as an agent, he can deduct that also. Balance amount, he can give it to the principal. He has a right to claim remuneration for the work he has done. But if he has done any misconduct, then for that part of misconduct, we will not pay him any remuneration. Guys, tell me one thing. Do we pay him no remuneration, or only for the part he has misconducted, we don't pay remuneration? Let us say an agent has misconducted. Okay? So I don't pay him remuneration for the part he has misconducted, or I don't pay him any remuneration at all. Tell me. Yes. So you cannot take away his full remuneration, only for the part misconducted. Now, if the agent does not get his money, can he exercise a lien also on the principal's property? Yes. But lien can be exercised only for the money that he was lawfully supposed to get from the principal, and it can be exercised only on the property that he has received from the principal in the ordinary course of the business. Okay? Then right to get indemnity. For any lawful act that he has done on behalf of the principal, he will be paid back any money that he has spent or any loss that he has suffered. Because he relied on the principal, he acted in good faith. Let's say for lawful acts, I tell you sell my goods, you make a contract to sell it, but I only don't give you the goods. You cannot give them the goods, so they sue you. Can you recover the damages from me? Yes. Again, acts done in good faith. I give you stolen goods to sell. You sell it off. The owner claims the goods from the buyer. So the buyer comes to you. Can you come and claim the price from me? Yes. Non-liability of the principal for unlawful acts. I tell you, go hit him. You go and hit him. He files a case against you. You are like, ma'am, you told I hit him. You give me money. I will say, I will not give. Why? Because I am not obligated. My liability is only for lawful acts. Even if I tell you to do unlawful acts, you cannot sue me for the money. And the last one, if because of the principal's negligence, the agent suffers any loss, he can recover the loss from the principal. Clear? With this, we are done with this. Can we go forward? So, what is the principal's liability to the third party? For any acts of the agent, can we say the principal is liable for any acts in the ordinary course? So, the principal is liable for all the authorized acts he has done. I am asking you to do the work for me. All the authorized acts, if you do it, I am liable. Second, principal's liability when agent exceeds the authority. Now here there are a lot of things. If both the parts are separable, I am liable for the authorized part, I am not liable for the unauthorized part. If both the parts are not separable, I am not liable at all. If the third party deals with the agent believing that agent has the authority to do the work because the principal made him believe that agent has the authority, you are liable to the third party, because what is third party's fault then? So acts is within and outside and they are separable. Then he is liable for the act within the authority. He is liable for the act within the authority. Acts which are not separable, he is not bound. If the act is done without authority and if the principal has by words or conduct induced the third party to believe that such act was within his authority, then obviously the principal is liable. Why? If principal made them believe he can do. If principal made third party believe that agent can do the work. If while dealing with the third party, the agent receives any notice from a third party, any knowledge, notice here doesn't have to be written notice, he comes to know about anything, it is deemed that the principal knows about it. So see, any notice will have the same legal consequence as if it was given to the principal. So any notice given to the agent is deemed to be a notice given to the principal. Okay? And the last one, if the agent has done any fraud or principal has not done fraud. Principal gave his goods to the agent did fraud with the third party. So fraud में क्या होता है? Contract is voidable. Now please, principal did not do any fraud, but still, can I say the contract is voidable against the principal? Yes. the third party can cancel the contract. Right? Is it clear? We have finished rights. We have finished rights. We have finished principals, liability to third party. Before I go forward, any doubts, please ask me, otherwise we'll move forward. By the way, Rajnikant, you say no, proceed ma'am, proceed. मेरे को लगता है कि समझ में भी आ रहा है कि नहीं आ रहा है. I'm having my full doubts. Anything is going here or not? Everything is going here. Continue. Priya, where were you since 2-3 hours? Now, personal liability of an agent. Just read this guide. Nothing to explain here. Just read it once. I'm here only, read it. Okay. If the principal resides abroad, who will go and file a case outside India? It's the agent. If he does not disclose the name of the principal, this is what? Unnamed principal. That means I say I'm the agent, but I don't tell him who is my principal. Undisclosed principal means the agent acts in his own name. That means what? He does not say that I am an agent. Rather, he says, I want to make a contract. Non-existent or incompetent principal, for example, minor, unsound mind, right? Pretended agent. What is pretended agent? You do the work for me without any authority. If I accept the work, I'm liable. Otherwise, who is liable? Agent is liable. When agent exceeds his authority, this both we have done in ratification. Right? If you remember, your dad tells you take 500, you take 1000. If dad says, okay, beta, no problem, money is for you only. You good, you stole money from me. Good. I'm happy. He has accepted, he is liable. But if he says, good, stealing money from your parents, this is what you're like. That means today you are getting flying chappals. Not accepted. Only liable for 500, you liable for personally 500. Clear to all of you? So moving forward. rights of the third parties, right? Rights of the third parties. See, till now we were doing what? This was duty of the agent. This is extent of agent's authority. That means what will be the liability of the principal or how much agent can do. Then this was duties of an agent. This was rights of an agent. Then we are done. What will be the principal's liability to the third party? Now, what are the rights of a third party? What are the rights of a third party? When the contract is made for an undisclosed agent, the third party will have a right against the principal. The same right, I'm just reading it carefully, listen to this very carefully. The same right as if he would have had as against the agent if the agent had been the principal. Means what? This is the third party, and the third party is making a contract with the agent. But you will get that only, don't worry. Flying chappal is only what you will get, and the eyes you will get. If you think that you will say, okay, it's okay, nothing. This will also be shaving your head only. Third party, okay? Third party makes a contract with the agent. Agent does not say that I am an agent. Okay? So, how the third party could have enforced the contract against the agent? Same way the third party can enforce the contract against the principal. Okay? See. The third party can against the principal have the same right. So when the third party makes a contract with the agent and the agent does not say I'm an agent, whatever rights the third party will have against the agent, the same rights he will have against the principal. If the agent had been the principal, if the principal discloses himself before the contract is completed, before the contract could be performed, if the agent comes and discloses himself, now listen carefully. The agent discloses that I am the principal discloses I am the principal. So basically what is happening is either he is not telling us the name of the principal, or if he is telling us he is not telling us the name of the principal, or he is not telling only I am the principal. So if before the contract is complete, the principal comes and says that look, I am the principal in this contract. The third party does not want to make a contract with the principal and cancel the contract. So see, if before the contract is completed, the contracting party may refuse to fulfill the contract if he can show that he had known that the agent was not the principal, he would not have entered into the contract. That means what? He can cancel the contract if he proves that had I known the agent was just an agent, I would not have entered the contract. That means what? Listen carefully. I make a contract with you. I make a contract with you. Oh my God, what happened to this? and then मेरा battery का laptop का battery खत्म हुआ तो I just put it on charge. I don't know what happened. The screen got disconnected. अब उसको deactivate करके कुछ नहीं. तो मतलब वो रुकेगा नहीं ना स्ट्रीमिंग. All streams will be shut down as well. Guys, can you hear me? Anyone is there? So, because only 2 topics are left, let's just continue and finish it off. Okay. So the first one we already did that. The second one, what are the rights of the third party? Performance of contract with agent supposed to be principal. That means what? That the agent, the third party makes a contract with the principal, with the agent, believing he is the principal. That is, let it glitch, guys. It's okay, doesn't matter. Let me just finish off. It's just 5 minutes. I really don't want to waste that time of ours. Let's just finish it off. You can see the screen. No, the screen is visible. It works. So, if the third party is making a contract with the agent believing he is the principal, he can get the same performance from the principal that he would have got from the agent. That means what? Whatever was the rights and obligations of agent, that same will be the rights of and obligations of principal, and he can ask the principal to perform the contract. Then the third party has a right to sue the principal or the agent. Now, please, this here I want everyone to understand. When he is making a contract where the agent is personally liable, in that case, the third party, this person is third party, may hold either him or his principal or both of them liable. That means when an agent is personally liable under a contract, the third party can make the agent or the principal both liable. On the other hand, when the third party has made a contract with the agent based on the term that only the agent will be liable or only the principal will be liable, then in that case, if the contract says only agent will be liable, he cannot sue the principal. If the contract says only principal will be liable, he cannot sue the agent. I hope it's clear to all of you. We are done with everything. Termination of agency. It can happen by an agreement between the principal and agent. That means as per the terms of the agreement. Or if he revokes the authority, that means if the principal gives a notice to the agent that I cancel your authority, or if the agent gives a notice that I will not be working as an agent anymore, when the agent is appointed for a particular object and the object has been attained, or when the agent is appointed for a fixed time and the time is over, death or insanity, principal has become insolvent, if the agent is a company and the company has been dissolved, or if the agent is a partnership firm and the firm is dissolved, that is death, and if the principal has become an alien enemy, in all of these cases, agency is revoked. One last thing that I want to discuss is sub-agent and substituted agent. What is sub-agent? He is appointed by the agent and he works under the authority of an agent. For the acts of the sub-agent, the agent will be liable. Can you appoint a sub-agent? No. You cannot appoint a sub-agent. Right? So, can be appointed only with the approval of principal or as per the terms of the contract, or if it is the custom. If he is appointed like this, we call him as properly appointed. If he is properly appointed, then to the third party, principal is liable. But agent liable to the principal. So basically, I repeat again, you cannot appoint a sub-agent because if you remember, duty not to delegate. And if he appoints a sub-agent, agent is liable for the acts of the sub-agent. However, if the contract says that a sub-agent can be appointed, or if the contract says that, or if it is the customer, I asked the principal and I appointed him, then it's proper appointment, and in that case, principal is liable. But the agent will be liable to the principal. Principal will be liable to the third party, but the agent is liable to the principal. What is substituted agent? He is appointed under the authority of the principal. And for the acts of the substituted agent, who is liable? Principal is liable. Only one case agent is liable if agent was negligent in appointment. He did not take proper care. He was negligent while appointing. Then he is liable. Then agent is liable. Otherwise, substituted agent is working under the authority of the principal. So the principal is liable. Guys, with this, we are done with Indian contract. We are done with the law syllabus. And finally, it's over. I'll be seeing you again. We'll be doing some writing practice. There will be a lot of things that we'll be doing undoubtedly. So I'll be seeing you again. Busy. But till then, keep studying properly, guys. And if you have messaged me your doubts, I have tried to respond to most of the doubts. If I have missed out, please message me again. Okay? Can I end the session here, guys? We end the session here. Yes. So guys, all the best. Keep studying, and if you have any doubts, drop in a message. Hopefully, I'll see you again soon online. Till then, take care. Bye bye, and all the best, guys. All the best. First chapter, there is nothing to teach. There is nothing to revise. Okay. Even if I do, I'll just be marking. Also, that is. You still want, I can do it because maybe 20 minutes. Okay. You want me to do the first chapter? There is nothing actually to explain also in that. It's just core theory. You still say I'll do it, but you want me to do the first chapter? So basically, Indian regulatory framework, this actually tells us why we need to study law, right? This basically tells us why we need to study law. So the first ever, so what is law? Why we need law? This is what it talks about. So law is nothing but a set of obligations, right? The first ever written law was the Code of Hammurabi, which was in 450 BC. Now, what are the sources of law? We get our law from, obviously, the first and the most important source of law is what? Constitution. After the constitution, we have the laws which are made by the parliament or the state assemblies. Then we have the judicial decisions and the customs and usage. These are the sources of law. Now, when we talk about the Indian judicial system, the Indian judicial system is a federal one which was given in the Government of India Act 1935. Federal means the power is distributed between the center and the state. And how do I know that it is distributed between the center and the state? Because it's given in the constitution that the power of making laws lies between the center and the state, because we have the central list, the state list, and the joint list. The federal court was established in 1937, which jurisdictions it had? It had the appellate jurisdiction. It has the jurisdiction of appellate, that is we can file appeals, original jurisdiction, that is the first case, and advisory. It used to advise the Governor General in matters of public opinion. When it was appellate, appeals could be filed for both civil and criminal cases. So appeal went to for both civil or criminal cases. It operated for how many years? 12 years, and roughly 151 cases were heard. It was later supplanted by India's apex court, that is the Supreme Court of India. Now, how do we make the laws? How do I make the laws? Yeah, I had a PDF. I'll share that PPT. First of all, the law, a bill is made. This bill is first placed in the Lok Sabha, then in the Rajya Sabha, where it gets the consent. Once it gets the consent, the president signs it, and then it is notified in the official gazette. Once it is notified in the official gazette, it becomes a law. Once it is notified in the official gazette, it becomes a law. How do we enforce the law? The law enforcement is done by the government. If it is a state law, state government; central law, central government. Obviously, government matlab kya? It is done through the various ministries. It is done to the various ministries. Through these ministries and their cabinet ministers, the laws are enforced. So the government is the executive body, and it is this government who has to make sure that the laws which have been passed are in force. Now, when we say ministry, ministry is of the employed officials, and these officials are known as civil servants, right? And they are accountable through a minister. That is, they will have a head, and that head is known as minister, and through this minister they are accountable. Most major ministries are headed by a cabinet minister. So ministry, or all the ministries that we have, major ministries, they are headed by the cabinet of minister. And he sits in the Union Council of Ministers. That is, in the parliament, you have the Union Council of Ministers, he sits there. Types of law: we have criminal law, we have civil law, we have common law, and we have principles of natural justice. Criminal law, basically here, the motive is to punish the wrongdoers, right? And Indian Penal Code, Bharatiya Nyaya Sanhita, and in Code of Criminal Procedure, Bharatiya Nyaya, I give you the Indian name, I don't know why I have Indian name. Bharatiya Nyaya Suraksha Sanhita. So these are the two laws which govern the. So you will write Indian Penal Code, but along with that Indian Penal Code, you will also write the new names of the act. The Indian Penal Code gives us what is a crime, and the Criminal Procedure Code gives us the procedure to file a case for a crime. Civil cases are basically, it is about, the focus is on dispute resolution. This word should be there in your answer, rather than punishment. So they don't go for punishments, rather they go for settlement of disputes. So Civil Procedure Code is the law which governs. So family law, family dispute, property dispute, law of tort, these all, breach of contract, these all come under civil laws. Common law is a judicial precedent. That means it's a decision of the court. Can I say decision of Supreme Court is binding on all the lower courts? Yes. So judgment delivered by the Supreme Court will be binding upon the courts within the territory of India. And how do we know that? Because it is given under Article 141. You can remember the article number, it will be good. Now, the concept is to stand by what is decided, that is, stare decisis. You cannot, for the same offense, you cannot give different kinds of punishments, right? In one case, you say, acha, let it be. In another case, you will say, no, you will have to be punished. This is not right. If the crime is the same, the punishment must also be same. So we have to stand by what is decided. Now, the last one, principles of natural justice. Nemo judex in quasi. No one should be made a judge in his own case. Like imagine you're checking your own answer scripts. Wow, 100 on 100. No, 110 out of 100. Audi altrum petrum, give the other party a fair opportunity of being heard. You remember your mom hits you, but still she'll ask you why you do all these things. So this is what Audi altrum petrum. Reasoned decision. That means whenever you come to a decision, you should have a justified reason on which you have based it. That is known as reasoned decision. Now moving to ministries, we have the first one, Ministry of Finance, which is known as Vitt Mantralaya. Vitt means money. Okay? It is a ministry of government of India and it is concerned with the economy of India. It concerns itself with taxation, financial laws, financial institutions, capital markets, center and state finances, and the union budget. One of the most important functions of this ministry is the budget, the union budget. It controls 4 central civil services. What? Indian Revenue Service, Indian Audit and Account Service, Indian Economic Service, and Indian Civil Account Service. And this ministry has 6 departments. You have to learn it. We cannot do anything. Department of Economic Affairs, Department of Expenditure, Department of Revenue, Financial Services, Investment and Public Asset Management, and Department of Public Enterprises. Then next one is Ministry of Corporate Affairs. In law, this is our most important ministry. Again, it is a ministry of the Indian government. It is basically concerned with Companies Act, LLP Act, Partnership Act, Bankruptcy, Insolvency and Bankruptcy Code. It is mainly responsible for the regulation of Indian enterprises in the industrial and service sector. So tax, finance, capital market, Ministry of Finance. But industrial sectors, this is Ministry of Corporate Affairs. It is run by civil servants of the ICLS category. That means they have positions, no? So their position must be this minimum. They are selected through civil service exams, which is conducted by the UPSC exams to clear the UPSC exam. What is the highest post here? Director General of Corporate Affairs. That is the highest post. Ministry of Home Affairs. Gria means home. Ministry of Home Affairs. It is a ministry of the Government of India. As an interior Ministry of India, it is responsible for the maintenance of internal security and domestic policy. So basically, the internal, security of the country is under the Ministry of Home Affairs. So it is headed by the Union Minister of Home Affairs. So this ministry has again 6 departments: Department of Border Management, Internal Security, Jammu Kashmir and Ladakh Affairs, Department of Home, Official Language, and Department of States. Department of Official Language is again classified into Central Translation Bureau, Central Hindi Training Institute, and Directorate of Census Operation. Then Ministry of Law and Justice, again, it is a cabinet ministry under the Government of India. Be very careful what words they have used. So it has 3 functions: management of legal affairs to the Department of Legal Affairs, legislative activities to the Legislative Department, and administration of justice to the Department of Justice. The Department of Legal Affairs actually advises the various ministries. So various ministries, when they make the laws, so the Department of Legal Affairs actually helps them in advising them on the laws. Securities and Exchange, it's a regulatory body, because Securities and Exchange Board of India relates to capital market, and capital market is under Ministry of Finance. It is under the ownership of Ministry of Finance. It was established on 12th April as an executive body and was given powers on 30th Jan 1990. through the SEBI law. Reserve Bank of India, it is finance, and finance is Ministry of Finance. So it is again under the ownership of Ministry of Finance. It is also a regulatory body. It's a regulatory body for the banking, Indian banking system. It is under the ownership of Ministry of Finance, Government of India. Main function of RBI, they issue the currency notes, is the issue, control and maintaining supply of the Indian rupee. It also manages the country's payment system. Like, you know, you make the Paytm payments, the Google Pays, GPay, all of it. Who actually takes care of it? Reserve Bank of India. Bharatiya Reserve Bank Note Mudra, that is the printing press. Where is it situated? Nasik and Dewas, where they print the currency. It established the National Payment Corporation of India to regulate the payment and settlement system in India. That is, how will the banks settle the payment, and all that system is designed by this National Payment Corporation in India. Deposit insurance and credit guarantee corporations was established. So basically, when when a bank gives loan and all, what is the security for the bank? This security is actually created by the RBI through their deposit insurance and credit guarantee corporation. Insolvency and Bankruptcy Board of India. It is again a regulatory body. Okay, so it regulates and oversees the functions of insolvency professional agencies, insolvency professionals, and information utilities. It was established on 1st October and was given powers through the Insolvency and Bankruptcy Code. Whether you are an individual, whether you are a company, a body corporate, whether a partnership firm, LLP, everyone will be governed by this. Okay, so individuals, companies, LLPs, and partnership firm, all of them, if they want to be declared insolvent, they will come here under this board. What is the main function? To simplify the process of insolvency and bankruptcy. So whenever a person wants to be declared insolvent, he'll go to the court. So the process is done by the IBBI. And there are two tribunals through which it does the work, NCLT, and that means case is filed. So they don't go to the normal court. So this case is filed through NCLT or Debt Recovery Tribunal. Now, structure of Indian judicial system. So basically, there can be a dispute between two persons or between a person and state. What are the functions of judiciary system? First, their function is to interpret the laws. Second, to settle the dispute and to promote fairness. That means what? You settle the dispute and you should promote fairness. That means in your eyes, everyone is the same. So at the top is Supreme Court. It is the apex body. It was established on 26 January 1950. Chief Justice of India is the highest authority, right? And he is appointed under Article 126. Under Article 126, we appoint him. It has 7 members, including the Chief Justice, but now it is increased to 34. Including the Chief Justice, there are 34 judges now. Under Article 32, if your fundamental rights are taken away, you can directly go to the Supreme Court to file a writ to get relief. Whatever is decided by the Supreme Court is binding on all the courts in India. Article 141. As per Article 141, decision, this we already discussed, is binding on all the courts. Below the Supreme Court is the High Court. It is the highest court of appeal in each state. Each state will have one. India Supreme Court is one. High Court is each in one state. In fact, it is given in Article 214 that every state must have a High Court. It is given in Article 214 that every state must have a High Court. High Court has appellate, original, and supervisory jurisdiction. What is the supervisory jurisdiction is given under Article 227. India has 25 High Courts. The 6 sisters have one single High Court. If your fundamental rights are taken away, you can directly go to the Supreme Court under Article 32. You can directly go to the High Court under Article 226. The oldest High Court in India is Calcutta. Below the High Court, we have district courts, right? The court of, we have two here, the Court of District Judge and the Court of Sessions. Court of District Judge is for civil and Court of Sessions is for criminal matters. When it comes to pecuniary jurisdiction, that is monetary, they can take up case of up to 2 crores, not more. And cases are decided on the local limits. That means which court you can go to. This is decided as per the local limit. Below the district court, we have metropolitan. Every metropolitan city or every city with 10 lakh or more population will have a metropolitan court. Chief Metropolitan Magistrate has the powers of Chief Judicial Magistrate, and Metropolitan Magistrate has the powers of Court of Magistrate of the first class. We don't have to do the powers that's given under the Civil Code, but we don't have to do it. With this, we are officially done with everything, not left anything at all. And now I will take your leave here. Guys, we are done with it. I hope you studied very, very, very well. Okay? So can we just end the session here now? Okay. Well, I'll see you all again very soon. Till then, study well. Bye-bye. Take care. Bye-bye. 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 Bye guys. All the best. Keep studying. Okay? And if you have any doubts, please